A prayer for adjournment has been made by Sri R. Dhar, Lion Standing Council, WPT and BC Department. Para. The matter is accordingly adjourned to be listed on 6th of November, 6/11.
Deep location.
My lord, may I please just for, my lord, pray for a listing of a motion on
Motion matter. When?
22nd, my lord.
Today is
My lord, 16th, my lord.
motion why 26?
Yeah, my lord, actually, my lord, it is numbered also. My lordship was pleased to allow it for today. But my lord, it has not come up, my lord. My lord, may I pray that?
Have it tomorrow? Tomorrow?
My oblige.
My lord, this matter may be listed for admission, my lord, because here my urgency is that the petitioner is suffering from cancer and the matter relates to non-payment of bill. She is the principal of a training institute, my lord.
Non-payment of what bill?
My lord,
Non-payment of what bill?
of bill, my lord, regarding training, my lord. She was supposed to get from the Department of Employment of Crafts and Training, my lord.
How is the principal entitled to a bill?
My lord, because, my lord, some students, my lord, 30 numbers of students were, my lord.
Matter of which
admitted
year?
For training, my
Matter
lord.
of which year?
24, my lord, 23, my lord,
Okay, exception. We'll have this on Wednesday next.
yes.
Maybe lordship. Lordship. I beg to mention WBC 876/25 listing on 24 October in this month.
What is the matter about?
Matters land dispute matter.
Land dispute, no urgency. So is it a fresh matter?
No, lordship. At that time, respondent service is not clear.
It's
They
not a
are-
matter
they are
for
from
out
local
of turn listing by a mention memo. Sorry. Yes, next.
May I please, your lordship, I want to mention regarding 2 contempt matter and 1 writ petition, lordship. Contempt,
Contempt, what is the urgency in a contempt?
it's 2024 contempt, lordship.
What is the urgency in a contempt?
It's regarding the petitioners, they are not getting their salary.
So what is the urgency in a contempt? Are you executing the order by a contempt petition? Of course not. No urgency, sorry. Unless you show an urgency for an order or admission, we are not allowed. Motion is different, sorry. Yes,
For writ, lordship,
writ petition, what is the urgency?
writ petition is regarding the land acquisition by the National Highway, lordship. For
What do you seek in the writ petition? What is the relief?
relief is money, lordship, compensation.
You make an application to the registration, not by mention memo, sorry. Yes, Forest.
Yes, your lordship, similar matter, yesterday only my senior had appeared.
Fine.
They are
Which
already.
order?
My lord, this is of. My lord, similar only thing, my lord, this area wherein we are residing has been earmarked as a long back as a disputed area belt, my lord. And
Disputed means what kind of dispute?
disputed means, my lord, there is a land dispute between the state of Nagaland and the state of Assam, my lord, border dispute. So, my lord, the Honorable Apex Court has issued an.
Residence of number 3 is Taluk Patar.
No, my lord, this is of Gelajan. We have mentioned, my lord, the area is at page 15, my lord.
Respondents are the same.
Same.
Who's for this Union of India? Union of India on behalf of Arkiti Chaudhary, LDB.
My lord.
LDB and on behalf of Arkiti Chaudhary, huh?
Upon is forest strong.
The VI or BI? Then PN Goswami, Madam M. Kolita.
2, 4 and 5, your lordship.
2, 4, 5, 6, 7, 8 and 9. No. Oh, Mr. Goswami is there, okay.
Yes, ma'am.
Then Ann Butler, Standing Council, Revenue, who's there? PR.
Except 3, my lord.
PR Mohanta, yes, PR Mohanta.
1 and 3 are.
Yes. PR Mohanta, hobo, huh? And the first area would be not Taluk Patar, it will be what?
Gelajan, my lord, in paragraph 2, page 15, my lord. Number 3, Raja Pukhori, Koiri Gaon, Biddapur, Sorupathar, and Biddapur, Gelajan, my lord. Paragraph 2 at page 15, my lord.
Okay.
Mal.
Notice, my lord.
Yes, same, it will for side of one.
These are already being.
Only notice, my lord.
Yes, notice.
Yesterday's order, there is an indication of my lord interim order, my lord. But here is a case where they have already been evicted. It is their statement on oath, my lord.
Already been evicted.
Already been evicted, my lord.
No, we have already been, my lord, our properties has been demolished.
You come from different localities,
Well-
same argument is there.
Not the yesterday's case, day before yesterday's case, no, the earlier
Then
cases,
make the clarification, Mr.
Well-
Goswami.
my lord.
Simply they have given this, or your colleague has given this order, you have to make the clarification.
My lord,
Has contended that they did not come from the same
I'm
different
sorry, my lord,
locality.
that order will not be applicable here, my lord. Simple, copy.
Only notice.
But the eviction process has already been concluded.
My lord,
Okay,
my
okay.
lord.
It would have one side.
No problem.
It last 8 paragraph about like this. Sri Bhuya, the learned council has has submitted that the area in question is a disputed area. And an area in question is a disputed area among, between the state of Assam and Nagaland. Full stop. Sri Goswami, the learned AG, has however submitted that the eviction process has already been conducted.
My lord.
Okay. And then, okay, we'll make it returnable by 6 weeks.
Right.
No problem.
Obligation.
Or Jaga to paragraph 8. Okay. Yes, next.
May it please your lordship, I'm appearing on behalf of my senior learned counsel, Mr. A.K. Bhuya, who has been very recently appointed as the senior standing counsel for BTC. Since there are no available copies of documents with us, we request the honorable.
17 matter difficult, but we'll grant some accommodation because of the change in situation. When can we have?
After 2 weeks. my lord.
2 weeks will be long time. 17 matter. We'll have it on Thursday next. Okay? You may arrange the files. What is your name?
AK Das, my lord.
While Sri A.K. Das Learned Council is present for the petitioners, comma, a prayer for adjournment has been made on behalf of Sri A.K. Bhuya, Learned Council, who has been newly appointed as Standing Council BTC. Full stop, para. Considering the aforesaid prayer as well as the fact that this writ petition is of the year 2017, comma, a slight accommodation is granted, directing listing of this matter on Thursday. Next, give the date, please. 20, on 23, yes. 23rd,
22.
not 23rd, that will be for 28th and 21st are holidays. That will be on 27th. 27th.
Well, the writ petition has come at our instance. my lord.
Yes, yes.
We have mentioned, my lord.
Yes,
Well,
there is nothing to be decided here.
My lord, regarding the component of the cost, my lord, my friend has just said that the work is over. But my instruction gone, he's keep on working over there. If their allegation is that we are not paying the amount for the security. But if we are not paying the security, we will definitely not come. So my lord, let have some instruction, let it come on next week.
No, 19 matter security, PSO, why?
My
should
lord,
this-
because my instruction is there, the work is still progressing in that Karimganj district. Karimganj district. That much, my lord, because they have.
What is the work involved?
My lord, PWD work, my lord.
And why is there a threat perception?
State perception, my lord, because of that area where we have also local people that are obstructing.
Oh, yes, what is your instruction, Mr. Nath?
But here, lordship kindly see, but he has prayed for, kindly take up the order, my lord, the honorable court order, that is February 2022, 24 to 2020, my lord.
Which one? February?
24 to 2020.
Yes.
Well, the honorable court has directed us to take instruction as to whether the SP Karimganj is ready to provide security to the petitioner within the construction site. And the petitioner submits that he does not want any personal security, but in fact, it is his contention that he needs security within the work site, and to that extent, Borman shall take instruction.
Yes,
Thereafter, kindly take up the next order, my lord.
yes.
My lord, we have, my lord, placed before the honorable court, my lord.
Yes, yes.
2/3/2020, my lord.
Yes, yes. We have
Okay.
seen this. We have
Yes,
seen this.
yes. So, my lord, ultimately instruction is the instruction is that the SP will provide the security in the work site. His grievance is that he is a resident of Guwahati. He cannot go to the work site. Local people are creating disturbance. He cannot execute the work. In the writ petition, his case is that this is a PMGSY work, construction and maintenance of roads, 4 roads in Karimganj, and the time-bound project. If he doesn't work, ultimately he will be penalized and he will face consequences. But since 2019, my instruction is that PMGSY works, those are already closed. We are in 2025, 6 years, 6-7 years.
Works are already over.
And-
We are
and-
recording a statement.
My
Then the
Lordship-
condition will be there, if the work is still going on, this statement will.
No, it cannot be a continuous kind of a work. It
Well,
has to be the work which was mentioned in the writ petition.
No,
If you are, no, if you
My
are,
instruction goes.
no,
my
Mr. Roy Chaudhary,
Work
if,
is
no,
going.
Mr. Roy Chaudhary, if you are allotted further works,
No, no.
maybe of similar nature, maybe of different nature,
No, no.
but allotted by the public authority,
No, no.
then if you think that you need security, you can come up before this court.
That observation may be.
We will have the document.
Here, we have another difficulty. Because
No,
of
we are closing this.
Yes, Malab, because of pendency of this writ petition and the undertaking given by us, the SSRC State Security Review Committee in its every meeting, Malab, taking up this case, providing the security on payment basis. Petitioner is not responding, nothing, no payment has been given, but enjoying the security, Malab.
But-
That is my instruction.
No, to provide security PSO, it is on the basis of payment.
Yes, Malab.
But to give security at the work site, is it also on basis of payment?
Yes, Malab. And that is what is prayer number 1. He challenges, Malab, kindly see, Malab, prayer number 1. SP has said that you will be given security and you have to pay for 5 security person, you have to deposit 1 lakh rupees. That is his challenge, first challenge, page number 14. And second, he says that provide him security without any payment, Malab. That is page number, kindly come to page number 14. That is his prayers. Considering, Malab, the dependency.
What was the work, Mr. Roy Chaudhary here?
Well, at page 18,
17.
18.
9 months. Work was 9 months. 9 months.
Long gone, page 24, kindly see, Malab.
9 months.
Only that observation may be given if subsequent works is there.
But it has to be on payment basis.
Well, that,
And if any payment is due, we can go for recovery proceeding.
that is, it is up to them.
This is my instruction. This is my.
Heard. Sri P.K. Roy Chaudhary, Learned Counsel for the petitioner. Also heard Sri D. Nath, Learned Senior Government Advocate Assam. Para, considering that this writ, please have your seat. Considering that this writ petition is pending since the year 2019, the same is taken up for disposal at the admission stage. Full stop. It may be mentioned. This court has also noted that this matter was last listed on 4/1/2021, and thereafter it has not been listed. Full stop. Para. As per the facts projected, the petitioner is a first class capital B category contractor in the PWD and was allotted a work wide and work order dated 1/3/2019. The site of the work is in the district of Karimganj and was under the Pradhan Mantri Gram Sarak Yojana 2017-18. It is the case of the petitioner that he, being a resident of Guwahati, was facing immense difficulty, including threats, while in the execution of the work for which security was necessary. Full stop. Necessary at the workplace. The petitioner has challenged the action of the respondents in demanding,
Page 40.
demanding, what do you call a fee or what?
Malab, page 14.
No, what is it called, for fee or what? Demanding a
Security.
cost of cost for providing such security.
Logic.
Full stop. Para. Sri Roy Chaudhary, the Learned Counsel, has submitted that the that though the petitioner is not in requirement of any personal security, of any PSO, comma, such security is necessary at the work site, full stop. He has also submitted that the work is continuing, full stop, para. On the other hand, comma, Sri Nath, the learned State Council, has submitted that the work was of the year 2019 and the tenure is already over. Full stop. He has otherwise submitted that providing of security at the workplace is only on payment basis, and as per instructions received, the petitioner has also defaulted in making such payment. Para. After consideration of the facts and circumstances and the materials on record, this court has noticed that the work order annexed to the petition dated 1/3/2019 had provided that the time of completion was 9 months, full stop. More than 6 years have passed thereafter, and according to this court is unable to accept the submission that the work is continuing, full stop. This court is also not able to accept the submission that a special security has to be given at the cost of the state exchequer, and it has to be on the payment basis, which is the normal practice, full stop. Though the state is under a bounden duty to provide security to all the citizens, comma, provision of special security of the present nature has to be on cost basis, full stop. In view of the above facts and circumstances, this court is of the opinion that there is no existing cause of action, full stop. Accordingly, the writ petition is dismissed, full stop. It is, however, made clear that if any fresh work is allotted to the petitioner and there is any threat perception, comma, the petitioner can apply for providing security, which, however, has to be done as per the norms, existing norms. Full stop. The state would also be at liberty to initiate any proceeding for recovery of any default on the aspect of providing security at the worksite to the petitioner.
The only prayer in place of dismiss, can it be closed?
Closed.
Closed.
Hello, Sajman.
Closed with cost.
Hmm.
Closed with cost or dismissed?
Oh,
Mr. Kotoki? Closed with cost. Okay.
Hello, Badra.
You can take this back, Mr. Nath.
Lord,
Item number 3. Yes, old matter, Rinan Nagar.
Made. My lord, before my learned senior proceeds, my lord, there is an IA also pending where we have filed for vacating an order passed by this honorable court.
We are taking the
Yes.
entire matter for hearing.
Yes, my lord. My learned senior can proceed in that case.
Old matter.
Yes, my lord. Indeed, my lord.
May please, my lord, whatever in this case, in 24/10/76, my lord.
Borough for response number?
8, my lord. The
Yes.
private
What- Yes,
response.
these have just said, yes, Mr. Kotoki.
So on 24/10/76, my lord,
24/10.
76. Government requisition a plot of land of measuring 50 biga.
Yes,
Under Assam Land Requisition
64 Act.
64. For helipad purpose
At
at Beltola, my lord.
yes,
Thereafter, my lord, on 20/12/99, the
yes,
deputy commissioner de-requisition the land
yes,
that at page 21, I have annexed the order, my lord.
Yes.
Then in the meantime, my lord, we are in possessing that land, my lord, and residing there.
You are the owner of the land.
No, not owner, we are the enclosure. Admitted. Because as soon as de-requisition, the land reverted back to the landlord. my lord.
Mr. Burgaon is the owner.
Now owner, earlier owner is defined.
Yes.
That requisition, de-requisition order at page 21, your lordship.
Hmm. Hmm.
Then on 15/9/2009, at page 25, the deputy commissioner initiated a proceeding under Assam Public Premises Unauthorized Occupation Act
71.
71 and issued notice to the person residing there.
Yes.
Then a group of persons approached this honorable court, and this honorable court by judgment and order dated 2/9/2014 set aside the proceeding below by WPC number 4275/2009.
Because it is not a public premise.
This is a private, our High Court division then judgment was there, that as soon as de-requisition order was signed, they then reverted back to the original pattern. This judgment was passed in 2/9/24, my lord.
24 of
In-
2014.
2014.
Hmm.
Yes.
Yes.
In between, what happened? The original landlord sold out to land to the respondent number 8 by shall deed dated 2/8/2011.
Yes.
In the sale deed, my lord, your lordship, I am annexing the sale deed at page 33. It is important, my lord, have a look on it.
Yes.
Page 37. This is the sale deed, my lord. It
Yes.
start from there. Page 37, my lord.
Yes.
Third paragraph. Has your lordship got it? As per terms of the said agreement or the sale, the purchaser has agreed to purchase the scheduled property with encumbrance. That is, that the scheduled property is in possession of the unauthorized occupant under the statement. Same thing repeated in paragraph 6 also.
Hmm.
Then your lordship turn to page 38. Has your lordship got it?
Just a minute.
Even consideration was given in paragraph 6, my lord.
Yes.
Together with encumbrance that the scheduled property is in
Yes, yes,
possession of.
yes, yes.
Then it is 38, my lord.
Hmm.
Clause 2, my lord. Has your lordship got it?
Hmm.
The vendor have already delivered symbolic possession of the symbolic possession. My lord. Well, let's note it down. Now on 2/21, my lord.
Yes.
The respondent number 4 to 7 came along with armed guard, armed women constable in the site and handed over 2 bigger land to respondent number 8. This respondent number 4 to 7 are at that time official in discharge of their official duty.
Yes.
Just have a look at page 31, my lord. To satisfy your lordship, I have annexed the photograph
Page 30.
31. The first photo is respondent number 4. These are the armed guard coming with building construction house material. All armed guard with AK-47, 32 also there, my lord. Civil person. With civil, armed with civil dress, my lord. They came, therefore we assail it, the action of the respondent number 4 to 7 with 3 pairs, my lord, mainly.
Now, what is the status?
Status, my lord. So for 2 bigger land, their position,
What is the total area?
total area, according to their sale deed, 35 bigger, my lord.
Under your possession?
No, and those are the remaining in our possession. They are in process of occupying the land. They are only 2 bigger, they are now at present possessing.
The sale deed was for 2 bighas.
2 bigger.
No, for 35 bighas, my lord.
No, my lord.
Sale it was for entirely 35 bighas.
Sale deed for entire 35 bigger.
And 2 bighas were forcefully.
Taken by the respondent, handed over. Thus, therefore, my pair, limited pair, 3 pair were there. One is declaration that the operation carried out on 2/2/21 as illegal and unlawful. Not to disturb our possession. B, not to disturb our possession. First pair is action of 2 bigger is illegal and without authority of law. Respondent number 4 to 7. B, mandamus not to disturb without following due process of law. And thirdly, to investigate the matter, because how the authority, how the government official in exercise of the government power entered into a private land. That is my contention before your lordship. Now, respondent number 8 filed an affidavit. And in it, oh, my lord, one thing. While issuing the notice of motion, court granted a status quo order. Right?
Yes.
Now, your lordship, respondent number 8 affidavit at page 6.65, my lord. If I am not wrong, correction.
It starts at 46
my lord.
by Ankit.
Yes,
This is the name. By Suresh Goel.
Suresh Goel, my lord.
Yes.
Page 65, clause 4.15. Soon, Department Dexter said that soon thereafter, recently, when the Revenue Authority, Government of Assam initiated a process to evict the illegal encroacher from the land in
You
question,
are at page
65, my lord,
65. What?
Four-
six-
4.15.
Yes.
May I read it? That the deponent Dexter said that soon thereafter, recently, when the Revenue Authority of the Government of Assam initiated a process to evict the illegal encroacher from the land in question, the encroacher mob filed the instant writ petition challenging the said action of the state authority, wherein they are admitted to the fact that they are illegal encroacher and have been in possession of the land. What I want to impress your lordship, that respondent number 8 admitted it's an eviction operation. Am I clear to your lordship?
Yes.
And because of we approached this honorable court, this court granted a stay order, interim order. Now, paragraph 11, page 72 of the
Yes.
Lord, may I read it? 11, moreover, it's a fifth line.
Yes.
Moreover, the contention raised therein are mostly within the domain of the state authority, and state revenue authority will be in better position and platform to answer the statement made therein. that
Just a
it-
minute, please.
May I read it?
Moreover.
Moreover,
Just a minute, just a minute. Yes.
moreover, the contention raised by the
Yes, we have read this. The state will be in a better position to answer.
No, Milord, the contention made therein further said disclose that the initiative made by the state authority to evict the petitioner individual illegally occupying their land.
Hmm.
What I want to justify, your lordship, emanating on this point,
Yes.
that the respondent number 8 admitted that it is a eviction operation. That was
Yes.
the thing.
Yes, that was.
But Apart from this, the respondent aid never nowhere stated in the affidavit that they have applied for identification or mutation of the land. Nowhere stated in their affidavit.
Yes.
Now your lordship turn to affidavit filed by the respondent number 4, who was the circle officer at that time.
Page.
Page is start from 146 in my
Yes. Lakshajyoti
Das, my lord.
Das.
He himself admitted in his affidavit that he was placed under suspension time and again for his good work, my lord. Now,
Suspended because of good work.
yes, my lord.
Why?
I don't know. Otherwise, fellow, suspension is on DP. My lord, now the respondent number 4 admitted that he was present there. He went there for identification of the land. At the behest of respondent number 8, my lord. That your lordship find at page third, even page 152, third line. The respondent number 8 has paid for identifying the straight plot of land and for mutating their name in place of original
153.
patata.
Page
Page 152.
152.
Hmm.
Yes.
The third line, the respondent number 8 has paid for identifying the said plot of land and for mutating their name in place of the original patata. And your lordship will find page 154 where he deals with my paragraph 8. Third line, fourth line, my lord, the page 154. The contention made therein are denied inasmuch as it neither disclosed that the initiative made by the state authority to identify the land in question, further coming across the person.
Paragraph.
It is page, paragraph 12, relevant portion at page 154.
Which line? The
It is,
contention.
the fourth line, my lord, the contention made therein are denied inasmuch as it neither disclosed that the initiative made by the state authority to identify the land in question, further coming across the petitioner individual occupying the land in question, were done at the behest of private respondent aid, nor suggests that the same was done illegally without following due process by state authorities.
Yes.
Now the respondent number 4, who was the circle officer at the time,
Yes.
he was leading the entire operation. He himself, he said that I went there to identification. No, I just paused for a moment, my lord. I want to know for identification of land, my lord, so many armed guard, lady police, lady. Our case is very simple, my lord. This is a private patta land, private property. Law is clear, my lord. To be given an encroacher or trespasser, procedure has to be followed. Because of our apprehension, my lord, that similar thing will happen to us also, the other person who are residing. And therefore, we approach this honorable court with protection that we shall not be disturb our position without following due process of law.
Yes.
They raised one point, my lord, that our association is not a registered association. I clarified it in a recent affidavit that we are registered, we are having valid certificate also. That I made it clear. Now, in this present case, in 2023, during pendency, the respondent number 8 filed a suit also. And the suits bearing title suit number
479.
479/23, my lord.
Where?
In
Malad
Civil Justice Senior Division number 1
Kamrup.
for declaration of right title interest over 35 bigger entire
Kamrup Metro.
metro, my lord. Over the right title declaration over entire purchased land.
Hmm.
Second prayer, recovery of first possession. Am I clear? Recovery of first possession, my lord, from the suit land, that is 35 entire.
Yes.
Eviction of evicting the person, my lord.
Yes, recovery has to be preceded by ejection.
Eviction, my lord. As well as compensation and other things are there, my lord, permanent injunction. That suit is pending.
Your
Uh,
party is in that suit.
We, these petitioners were made party there. So we are fighting and that issue and document already been over.
Yes.
It is evidence. Therefore, this petition, my lord, confining not on title, not on any other thing, my lord, it relates to only on the day of 2/9/24. Whether that action of the respondent 4 to 7 over a private property justified. And when respondent number 8 said, I went to identify the land, and respondent number respondent 4 said, I went there to identify land, and respondent number 8 said, no, it's an eviction operation.
Okay.
Therefore, without due process of law, my lord, nobody can be evicted. And that is one of my prayer here.
Yes.
Look, only thing that sometimes it's always cropped up, whether apprehension of violation of rights, whether repetition is maintainable or not.
No, there's no apprehension here. It's not on apprehension. They have already gone there.
Gone there, there's others we are apprehending.
It's maybe a quite quitemit action. Which decision? Pasha?
It's a, my lord, State of Andhra Pradesh and others, my lord, 1964 Supreme Court.
Named?
State of Andhra Pradesh. I have copy.
Name. No, those are settled. SMD Pasha is an apprehension of violation of fundamental rights. You can move the writ court.
That, my lord, I am talking about.
But still then place it.
Paragraph 15, my lord.
Hilal Bhai on this.
Huh?
15.
It is it has been held by this court that where there has been a tweet only, the right has not been actually infringed as an application under Article 220 would lie, and the court would give necessary relief by making an order in the nature of injunction. Look, here in, I found though it's not related to,
but you read the next line.
my lord, line is,
Thereafter, next line.
next slide, my lord. And it will hardly be reasonable to say that while the court will grant relief by such command in the nature of order or injunction where the invasion of a right has been merely threatened, the court must still refuse, where the right has been actually embedded. Yet, to give, where the right has actually been embedded, to give the consequential relief and content itself with merely a declaration that the right exists and has been embedded and with merely quashing the illegal order made. Well, paragraph 16 also important. For this reason above, we are clearly in opinion that the High Court have power for the purpose of enforcement of fundamental rights and statutory right to give consequential relief by ordering repayment of money and so and so. Now, here in this case, I am confining that my prayer that though you cannot dispossess us without following the process of law. Therefore, my limited prayer before your lordship
Yes.
our apprehension that we may be dispossessed from the land, and therefore we approach it, this honorable court. They may, at that time, apprehension was there, my lord.
Yes.
Because we are still occupying our land, or possessing our land, but we are residing therein by constructing our house therein. So that's my humble submission before you.
Yes, Mr. Das.
Plus, that's the difficult. State has not filed, neither filed nor anything.
Doesn't matter, he has to defend.
Look, first and foremost, my lord, there is a maintenance issue will come up, my lord. Because at the relevant time of filing of this application, it was barred under the law, my lord.
Why?
Section 6 of the Society Act is very much clear.
Why? What is the required?
It should be registered, my lord.
Now, who are the petitioners?
The petitioners has been represented by one is.
Is the petitioner only the association? Or there are three other persons?
No, my lord.
There are three other persons.
No, my lord. They were the president and members.
Lord, look, kindly see the array of parties before making any submission. Are you confining a writ court to the issue of registration?
No, that's
We are
not-
exercising plenary jurisdiction.
This is one,
Registration would come if that is an issue.
no, this is one of
Registration
the.
is not an issue at all in this case.
this
Who
is-
has espoused the cause? We are looking into the cause. The registration, maybe you will have a point. If the registration would be an issue for adjudication of the dispute before us.
No, That's true, my lord.
And,
My lord, yes,
and
that's it.
2, 3, 4 are there.
My lord, let it be taken 172 page.
No, not required.
My lord, I have
No, no,
the
no, no,
certificate.
Registration is not.
But on the relevant time, I'm saying.
Yes,
Yeah,
I know.
This is the thing, you see
Yes,
the valid up to Iman,
Uh,
validity extended from there.
It's a case of 2021.
Yes, validity
No,
extended.
Mr. Das, Mr. Das, even if we assume that at the time of institution of the writ petition, the petition number 1 was not registered, that will perhaps not bar the
That's
petitioners.
one of my submissions.
Yes.
My
My
lord,
lord,
I made
No,
it
no, we'll
clear.
come back to you, Mr.
my lord,
We'll come back, let him make the submission.
My second submission would be with regard to my lord, the causes, what my learned friend has been put before your lordship.
Hmm.
Already a civil suit has now been filed,
Yes,
and his only submission is that due procedure will have to be
Correct.
followed before eviction.
yes.
That will take care of by the civil court, my lord, because
Yes.
the due procedure has already been filed. So as per my submission at present, this case is infrastructure, my lord. Because they also cannot come to any illegal act because my suit is pending before there, which my learned friend in fact brought by an affidavit. Apprehension.
No, but what about the, how do you justify 2914 action?
2914 action, man,
It's a private property.
it's a private,
You can go for demarcation, that's not a problem.
yes, man.
But you cannot go for eviction unless there is a valid decree to back you.
Yes,
Decree for ejectment,
yes,
decree for recovery of possession, whatever. We are not for a moment with the petitioners on their illegal possession, but you have to evict by following the due process of
yes,
law.
yes.
And Mr. Burago's client has purchased this property. Even there is, even assurance free,
Yes,
let us assume that there is no such clause,
yes, yes.
that he buys
Yes,
it.
yes, yes.
Then also, if he finds that the property is encroached, he can take law into, take the recourse of law,
Yes, yes. My
which he
lord,
has done ultimately.
personally, he has made the circle officer the party in this case.
Hmm.
And in fact, he has filed an affidavit in this regard.
Yes, who is his counsel?
Uh,
Yes. Okay, we'll come back to you also.
Since my lord, state has not filed any affidavit. Exactly, my lord, on that particular incident, what
Yes.
happened, that is not before the court by way of affidavit from the state side, my lord.
Now, what we have also noticed, and we have not come to madam, we'll hear her, the respondent number 4 in his affidavit has stated that from memory he he remembers.
Yes,
He cannot say from memory.
memorial. Because he also.
There has
said
to be
that
some
presently-
proceeding,
Yes,
some proceeding before him.
yes. Obviously, some application will have to be filed.
Yes, yes,
It is also true, my lord, an application will have to be with regard to mutation or demarcation,
demarcation.
nothing beyond that. Until and unless an decree is.
Yes, yes,
Obtained.
you are absolutely, you're correct and you are taken a very reasonable stand. Yes, Mr. Buragohain.
Yeah.
Anything more, Mr. Das? Anything more?
Since no affidavit,
Okay.
only my submission maybe.
Yes, yes, definitely.
May it please,
That is why we have heard you.
may it please, Your Lordship.
Yes.
My lord, I have prepared a brief list of dates and incident in a chronological manner, which my lord,
Mr. Buragohain, we can just put a caveat to you.
yes, my lord.
You know the issue in law before us.
Yes, my lord, of course.
Facts, we are not very
Not
interested.
interested, my lord, but
Since you have also instituted the civil suit,
my lord,
you be rest assured that we, whatever orders we pass in this,
my lord.
this will be without any prejudice to rights of either of the parties, not only you, even to them.
Either parties, correct.
They may be encroachers, but they have to be given a due hearing, everything.
Yes, my lord, of course. My lord, then, my lord, I will just place the most important and relevant point which my learned friend has just missed, my lord. The fundamentally why we are opposing this writ petition is on the ground of maintainability, which my learned friend has just pointed out, my lord. Now, the petition which has been filed is not actually has been filed by the proper person who are or were evicted on that particular point of time when they say that they were in possession. Why this is, I am submitting, my lord, because, my lord, these alleged registered body was never at any point of time was registered, even at the time when they filed. Your lordship will read paragraph number 2 of the writ petitions, where they categorically say that this petitioner number 2 to 4 are members of this association. They are not espousing the cause as independent affected persons to come before this court. I'll read that paragraph, my lord. Kindly come to paragraph number 1 at page 5 of the petition.
Yes.
That the petitioner number 1 is a registered association registered under Societies Act, having its registered office at Moidamgaon, Beltola, Guwahati, and represented by petition number 2.
Yes.
The total number of members of PSSR society is 216. This is very important, my lord. 216 members they have.
Yes.
Petition number 1 applied for renewal of registration on 17 March 2021. I don't know where is the application for renewal. He has not annexed and pending for disposal. Now come to the next point, my lord. Petitioner number 2 to 5 are members of the said association and are permanent resident of such and such place, my lord. And at paragraph number 2, if your lordship comes, they have repeated that this action undertaken by 4 to 7 has affected the petitioners, meaning thereby the petitioners and the members of this association. Now, my lord, pause here for a while, my lord.
Yes.
They say, and they have repeated that they have 216 members. Now, my lord, where is the authority of these 216 members given to them, even assuming as a registered association, to ventilate their cause before this court that these 216 people have been affected by the impugning actions from respondent number 4 to 7? There is no documents, my lord. This is the basic prerequisite, if I am correctly understood, my lord. If under Article 14 and 21 has to be invoked, independently, directly, the persons affected will have to come, my lord. There is no second route to the cause which has been ventilated by my learned friend, my lord. This part, they can come later on.
But if you are coming to 14.
Yes, my lord.
and 14, come to
Yes, my lord.
14.
Yes, my lord. Article 14.
14 is not confined to a citizen. It is to a person.
Exactly. He has to be juristic person, my lord. That is what my
No, but
submission is.
the first paragraph, you read the first
Yes, ma'am.
paragraph,
Yes, my lord.
first paragraph itself.
Yes, my lord.
Petition number 1 applied for renewal of registration.
Yes. Where is
that-
the renewal? Where is the renewal document, my lord? He has to, my lord, he can make number of submissions, and I'm not on that. I'm not questioning the veracity, but the obliged duty of the petitioner
Let us see the registration first.
of, my lord, Article 14.
No, registration.
There's no registration, my lord. There's
Yes.
just now the affidavit which has been filed, the affidavit which has been filed by them saying that it was registered, which my learned friend has just pointed out, there they have registered it in the year 2021, no, 2027, my lord.
27, 17.
Sorry, my lord, 76 one, in 17, my lord. Now the certificate, if your lordship sees, certificate of registration issued number, the page 172, my lord. Now this is a fresh number UBIN they have given, number 2024, my lord, issue number such and such, number such and such. I hereby certify that Union Nagar Committee, so and so, district PIN number has been registered under Societies Act and given under the so and so on 8/9/2008, valid up to 16, my lord. So from 16 to the time they have filed this case, in between there was no registration.
Now thereafter, the next line, validity extended up to.
Extended. This was subsequently, if my learned friend says that they have applied for it, the onus was on their part. Yes, the affidavit. Yes, my lord. If
Now, if there is a delay in extending renewal,
I'm not on that, my lord.
no, if you do not dispute the next line, validity extended up till
Of course.
1/8/2027.
7.
And as on 25/2/2016, it was valid.
Valid, my lord.
The writ was instituted in
Yes,
the year
No, my lord, kindly come
2021.
to the affidavit. When they filed the affidavit, the writ was filed on
In the year
22nd
2021,
of March 2021.
yes.
So from 16 to 21, there was no validity.
No, the petition for renewal was lying. That is the disclosure made.
So when 17 March, that is what exactly I'm saying. Kindly, lordship may come to the paragraph. When did they apply for renewal? At
No,
page number
Mr.
5.
Boragohan, we may not even go to the issue, but since you have raised the issue,
My lord.
once it is extended, validity is extended on 1/8/2027.
Yes, my lord.
Can you say that at a intervening time, it was not, since it was not, there was no renewal, so it will lose its registration? It cannot be.
My lord,
It's not a new registration that had applied, not given. It was a application for renewal. If the renewal takes time,
My
you
lord.
cannot find fault with the applicant.
My lord, this is one
Yes, for a
aspect.
new entity, you may be correct.
Definitely.
You apply, not given. You did not take steps, but you are an established, you are a registered entity.
My lord. So
But
if-
that may not come into the,
My lord, my
because
lord,
there are many case clause
Yes, my lord.
that registration or non-registration may not be.
Why I'm raising this point, my lord, is for the reason, my lord, 216
But
members
that we have taken, that we have taken note of.
alleged.
That we have taken note
Yes,
of.
not a single person, or they have not even named these 216 by giving a list appending to this association, alleged association, my lord, that these are the people who are deciding, my lord. Now, the problem where it started, my lord, before coming to this court, they have concealed some material facts. An FIR was lodged by one of the directors of this company in the year, my lord, 2021, around in the month of, my lord, I'll come to the FIR in my IA. If your lordship sees, if your lordship might take up my IA for vacating the stay order. There I have given the FIR, my lord.
Page.
Take a look. Page 64, my lord. My FIR is at page 60, my lord. 60. This date of this FIR is very important. One of the director 20
Page.
March 2021. Page 60, my lord, of my IA.
FIR dated.
20 March 2021. I pause here for a while, my lord, and the incident which they allege to have occurred is on 2nd of March, the 2nd of February.
2nd of September.
No, my lord, it's February, in the
Oh, sorry.
2nd of February, my lord.
2nd of February.
Yes, my lord. 2024, my lord, 2021. At page number 10, paragraph number 8. Page number 10 of the writ petition, paragraph number 8. However, all of a sudden on 2nd of February 2021, respondent number 427 came to the vacant land along with armed police and lady constable.
Just a minute, please. Second of February, yes.
2nd of February is the alleged incident which took place.
Yes.
And my lords, it is on 2nd of February. They came much later. Why they came, this FIR will indicate, my lord. At page 60, 20/03/2021 is the date of the FIR lodged by one of the directors of this respondent company, wherein your lordship will come to the contents of the FIR at page 62. If I may read, my lord.
Yes.
Informant, Sri so-and-so, director so-and-so. Now, accused name. This accused, Jotin Rajbangshi, Dipankar Medi, Sunil Boro are the petitioners here, my lord.
Yes.
Are writ petitioners. With due respect, I beg to state that I am the director of so-and-so private limited company, that I would like to inform you that MS East Infrastructure is the absolute owner and for plot of land measuring such and such because, my lord, under so, my lord, which is the land measuring such and such. So that which have been purchased from original Patadar of our company by registered sale deed number such and such dated 2011, registered before the sub so and so. Next page, my lord. That by virtue of the aforesaid registered sale deed, the East Infrastructure is the legal owner of the said land, and while our company intend to develop the said land, it has come to our notice that without having any legal authority, ownership, without any lawful entitlement, create legal tenancies, agreement to sell and construct unauthorized structures thereon and the above mentioned plots of land.
We have read this. What about the Land Grabbing Act?
Yes, ma'am. So from this, the matter was sent to the Honorable District Judge. A land grabbing case has been now, my lord, initiated. The initial depositions has been made. A circle officer report has also been submitted. If your lordship allows me to place the report of the circle officer in the land grabbing case, there they have indicated that these are the people who have been occupying.
Now, what is the status of the land grabbing case?
It is at the stage of, my lord, hearing on the report submitted by the circle officer, which we have admitted.
What is the registration number of the land?
Yes, madam. I have given the certified copy, madam. That is the land grabbing case.
(100) 2021. Before whom?
Before Honorable District Judge, madam.
Additional Session Judge, number 1. Yes.
Now, my lord, the difficulty here is, my lord, with the by virtue of this status quo order passed by this honorable court, they are enjoying the status quo order. Now, during the pendency of the writ petition, we approach the honorable civil court by filing a suit. My lord, that is a title suit which my learned friend has stated that we have claimed right title in interest for eviction and for recovery. Now, Here, there is an injunction application pending, which is, my lord, the application filed under under Order 39, Rule 1 and 2. And in that application, when we move the application, the Honorable Court have
Injunction for?
injunction for restraining these, my lord, illegal encroachers from creating further encumbrances, because every day they are violating their own orders. We have stated categorically, they are creating new encumbrances, renting out the premises, even selling those plots of land by way of kacha holil in the past. So these are all allegations we have brought in the suit. Now the court hesitate to pass any interim order injunction in the light of the fact that they have been in occupation of that land. So the court wanted to issue a notice to them without hearing ex parte. So notice was sent, they entered appearance. They in fact have gone there, have filed 4 counterclaims, my lord. No, my lord, 4 of them have, my lord, they have appeared. My lord, they have filed 3 counterclaims. But the interesting part is that the Trinidad Society is also a party there in my suit. Now the suit, Trinidad as defendant number 1, has filed the written statement contesting our claim. But when the counterclaims comes into play, counterclaim has been filed by this 3 accused person. Why a counterclaim has not been filed by the registered association? Knowing this very well, because at the time when they filed a counterclaim, they knew that did not have any jurisdiction, significance or entity.
No, if they are separate defendants,
No,
they
they
cannot be
are
restrained.
they are being made a party, my lord, as a members of the association, because we
Yes.
never knew who are in occupation. Because 206.
No, if an individual is made a party defendant
Yes,
in
my
a
lord.
suit, there cannot be a restraint
No.
for filing a counterclaim, only
Only for-
because the other defendants have not filed. He may
What I'm
somebody
trying-
individually espouse.
Of course, ma'am. What I'm impressing upon this honorable court, my lord, is that why or what prevented the Trinidad
So, Mr.
Society,
Buragoy,
My lord.
filing of counterclaim or any other thing, you cannot prevent.
my lord.
What you can do is direct the court to expeditiously dispose of the matter in accordance with law.
Yes, my lord. So we have prayed before the honorable my lord trial
And
court.
we'll clarify that without following the due process. You can take all action only by following the due process. Since the due process has already been initiated, let it come to a logical conclusion, take consequential action. We are concerned about your rights.
Yes, that is my lord.
You're valuable, you
my lord.
have invested.
Yes,
But
my
at
lord.
the same time, the rights maybe of encroachers.
Yes, my lord.
It cannot be just abandoned like that. There is a process laid down.
My lord.
The action which was taken on 2/2/21 does not prima facie appear to be in
Maybe, my lord,
accordance with
because
law.
that was at our request that we wanted the authorities, because there is a requirement under the law, under Assam Land Acquisition Act 1964, under section 8(1), if I may just place, my lord, that if the government has requisitioned the land, a burden is always cast upon them to give the land as it is, as is where its basis, to the original owner. So that was the only precaution we took to the authorities, saying that under 8(1), you now give me the land back the way you took it few years back, which was without encumbrances, my lord.
But
In my
there's
eye,
no-
I have placed that.
But the re-requisition was in the year 1999.
And exactly, because
And
the
when did
original
you
owner
purchase, when did you purchase?
in 2011,
2011. From 9 to 11, you did not-
1999,
Yes,
the matter was the land was the requisition.
re-requisition.
It was given back to the original owners.
Yes.
Even original owners somewhere around 2000.
You purchased the land on 2/8/2011.
11, correct, my lord.
Now from 1999 to 11,
My
you
lord.
do not have the control what has happened over the land.
In fact, I didn't have a control.
And your sale deed has also contained at least 2 clauses.
Yes, that it has been
That you
covered.
have purchased along with encumbrance.
Absolutely, my lord.
It's up to you to remove the encumbrance in
Yes, ma'am.
accordance with law. There
Yes.
is no restriction to that.
That
But
is-
this 2/2/21 does not prima facie.
Yes,
that
of
this-
course not, my lord.
No,
But
that will balance it, don't worry. Yes, madam.
only just one submission, my lord. Only thing is that if the interim order passed by this honorable court is allowed to continue, difficulty is that, my lord, our injunction application under 39(1) and 2 will have no fruitful effect, my lord.
No, there is
Maybe-
there is no requirement of directing continuation status quo. We'll make it clear
Yes, my
that
lord.
without following the process of law, you cannot evict.
Yes, of course.
Yeah,
Without
that-
following due process of even the lower courts, my lord, the trial court will also not take any actions against
yes.
them, my lord.
That
I'm
will
obliged,
take-
my lord.
that will take- Yes, madam, who are you?
Lordship, I'm representing
Your name?
MS S Nath.
Yes, not.
Yes, Lordship.
That's not for R4.
Yes, Lordship.
Yes.
Lordship, I would like to first point out that the submission that my learned senior has said that he is in suspension, which is not pertaining to this case, Lordship.
It's not pertinent.
Yes, Lordship. It is also stated in my
No,
affidavit.
not pertinent. We are only deciding the issue involved. What
Yes.
what is your stand?
Lordship, we were just following our duty, which was that we had just gone there to,
On the basis of what?
Lordship, there was a petition that was been filed.
Where?
Lordship, I have not annexed it in my
See,
affidavit.
you are standing for an officer who has made a defense that he acted in purported discharge of his duties, official duties. Official duties have to be backed by documents.
Yes, Lordship.
It cannot be on the basis of some knowledge or memory. Where is the petition? What is the number?
The matter,
Where is the demarcation case? Where is the partition case? Where is the order?
Lordship, the matter is that I am in suspension as of now. So.
As
if-
of now, you're in
Yes,
suspension.
Lordship. So the records are in the office and I don't have access to such records and hence I could not annex it in my.
When did you file the affidavit?
Lordship, I filed it on 5 September of this 2025. I received this writ petition on 7th July and I filed it consequently, Lordship.
5th of September, or presently you are in suspension?
Yes, Lordship.
Okay.
Yes, Lordship. I do not have access to such documents.
You do not have access to the documents,
No,
okay?
Lordship.
And what else?
I was just following the due process in law just to initiate the process of identifying and mutating the land on the request of respondent 8, Lordship.
On the request of R8, a petition copy you are not in possession. Mr. Boragmoy, have you given
Yes, Madam.
your petition
We
copy?
have given a petition.
Where?
To the authorities.
No, where is it?
No, we haven't annexed that, my lord, document. No, because that point never arose, only because when this came into play, my lord, that's.
No, as a response to the writ petition, you have not enclosed the
No,
application for mutation.
we didn't keep, what I have been told and instructed, that application was filed before them to demarcate, identify, and if possible, because section 8(1) will come into play, I have just submitted that the government needs to give me the land in the same manner they have taken under the Act of 1964, my lord. So that was what.
Now, government will give not you, the original owner.
Exactly.
You are not the original owner. You came into,
difficulty is that
you
when I
came
have
into the
taken the
picture
land-
when? You came into the
2011,
picture on 2011.
Absolutely, my
The
lord.
revision was 1999.
Right.
99 to 2011,
Yes, my lord.
more than a decade has passed.
Pass, my lord. So I would
In one day,
expect-
there is a change on the status of a land.
It has
Within
been-
an hour.
That-
In
that is the
decades,
difficulty, my
it
lord.
might exchange many hands.
My lord, absolutely, that is the difficulty, my lord.
Okay.
Anyway, my lord.
Anything else, madam?
No, Lordship. That's all.
Mr. Kotoki, there are decisions where registration, in spite of not being registered,
My lord,
writ petition can be entertained.
no, my lord, I am coming to that, my lord.
You make
You
a-
know, that judgment, my lord, if you, I can give the citation as well as paragraph number, my lord. AIR 1981 Supreme Court 298, paragraph 63, my lord. Unrecognized association,
AR
1981 Supreme Court, my lord. Page 298, paragraph 63, my lord.
name,
Name, my lord, not, me, my lord. Yeah, here, the Supreme Court held that unrecognized association can approach the writ petition
unrecognized or unregistered.
unrecognized because that is the trade union under that registration required under the Trade Union Act. You know. Therefore, Supreme Court held that unrecognized. Because trade union, my lord, your lordship, aware that trade union is required registration under the Trade Union Act, my lord. Therefore, my lord, what I submit that
এই মূল টেপ তুলে নিয়ে আসুন WPS
the, as your lordship politely pointed out, the original landlord can claim, but that has been changed. He purchased it. That's true after 10 years.
AR 1981
Yeah, 1981, sir.
31 Supreme Court,
Supreme Court,
298, paragraph 63.
era 63. এইটো অকল PIL কাৰণে ছাৰ দোকানৰ বৰ্ড কৈ দিছিলে এইটো আপোনাৰ ৰয়েল হেৰিটেজ কাউন্সিল এইখন হয় ছাৰ
অখিল ভাৰতীয় সুশীল
Yes, sir. Yes, madam.
That's, let's see,
If it is in nature of PIL, madam,
no, not, তাতে লিখা আছে, when there are a lot of people are there,
মানে আপুনি এই লিষ্টখন দিয়া নাই তো ছাৰ
মানে এই paragraph 15 মোৰ পঢ়া আছে।
Okay.
Look, I have also stated in my paragraph 15 that we have apprehend and therefore this is petition. In my paragraph 15, I have specifically said why I approach this honorable court, paragraph 15 below. The petition is to state that they apprehend that the respondent shall adopt similar process in future to evict and forcefully dispose from the land possessed by him. That is why I approach this honorable court. Into 8 minutes.
Okay. Please have your seat.
Yes, madam. Obliged, madam.
the petitioner number one, which is an association, along with 4 of its members, have approached this court under Article 226 of the Constitution of India, challenging inter alia the action of the respondent numbers 4 PO27 taken on 2/2/2021, dispossessing, evicting the petitioners and evicting the members of the petition number 1 from land measuring 2 bigha 1 katha of Dag number 586 of KP Pata number 75 and handing over possession of the land to the respondent number 8. Full stop. It is the contention of the petitioners that such action is wholly without any jurisdiction and not supported and not backed by the mandate of law. Para. As per the facts projected, the petitioner number 1 is a registered association and the other 4 petitioners are its members. Full stop. The area in question is a part of a land measuring 50 bighas, which was requisitioned in the year 1976 under the Assam So-and-so Act of 1964 for construction of a helipad at Beltola, Guwahati. Full stop. However, due to certain change in the policy decision, the land was de-requisitioned by an order passed by the Deputy Commissioner Kamrup on 20/12/1999, and accordingly, the land had vested back on the earlier owner. Full stop. It is the admitted case of the petitioners that they are in possession of the land having residential houses. Full stop. In the year 2009, an action was initiated under the Public Premises Act of 1971 for eviction of the petitioner, and notices were issued on 15/9/2009. Full stop. The said notices were, however, the subject matter of challenge in a writ petition which was instituted before this court and registered as WPC 4275 of 2009. This court, after hearing of the parties, had passed an order dated 2/9/2014 interfering with the aforesaid action and had set aside the proceeding. Full stop. The primary consideration of this court was that the area in question was not within the definition under the Act of 1971. Full stop. The land was ultimately purchased by the respondent number, an area of 35 bighas.
35 bighas.
35 bighas was ultimately purchased by the respondent number 8 via a registered sale deed on 2/8/2011. Full stop. It is the contention of the petitioners that such purchase was done by the respondent number 8 being fully aware of the encumbrances on the land, and those were in fact the conditions of the purchase. Full stop. Nonetheless, symbolic possession was handed over. Full stop. On 2/2/2021, the petitioners allege that a large number of persons, including police personnel led by the respondent numbers 4 to 7, had entered into the land and had handed over 2 bighas of land to the respondent number 8. accordingly, the present petition was filed. Full stop. This court wide order dated ... while issuing notice had directed maintenance of status quo. Full stop. Correct. I have heard Sri S. Kotoki, learned counsel for the petitioners. Full stop. I have also heard Sri N. Das, learned state counsel, comma, Sri Miss S. Nath, learned counsel for the respondent number 4, and Sri H. Buragohain, learned counsel for the respondent number 8. Both the respondent numbers 4 and respondent number 8 have filed affidavit in opposition, followed by rejoinder affidavits by the petitioners. Para. Sri Kotoki, the learned counsel, has candidly admitted that the status of the petitioners are in the form of encroachers. Full stop. However, he has hastened to add that even if the petitioners are in the status of encroachers, comma, such encroachment is over a private plot of land, and without following the due process of law, they cannot be evicted. Full stop. He has submitted that though a move to requisition the land was made in the year 1976, the same was de-requisitioned in the year 1999, and accordingly, the land had vested back to the earlier owner, and the status of the land was reverted to be private land owned by the earlier owner. Full stop. He has also drawn the attention of this court to the sale deed dated 2/8/2011, which contains specific conditions that the purchase was made with encumbrance and only symbolic possession was handed over. Full stop. He has submitted that the impugned action taken by the respondents numbers 4 to 7 on 2/2/2021 is absolutely illegal and not backed by any law. Full stop. He has submitted that there cannot be any forceful eviction without following the due process of law. He has reiterated that there was no orders by any lawful authority, not to talk about any court, permitting for such eviction. Full stop. By drawing the attention of this court to the relief prayed for in this petition, the learned counsel has submitted that apart from the petitioners numbers 2 to 5, there are in total 216 members of the petition number 1, and there is a genuine apprehension of further eviction, and accordingly the writ petition was instituted. Full stop. Relying upon the case of the Constitution Bench of the Honorable Supreme Court in the case of State of Madhya Pradesh versus Bhailal Bhai, reported in AIR 1964, Supreme Court 1006, the learned counsel has submitted that it has been settled that a writ petition can be moved even on a bona fide apprehension. Full stop. He has submitted that the overt act of the respondent numbers 4 to 7 done on 2/2/2021 would amount to a bona fide apprehension, and therefore this writ petition was filed in which notice was issued and an order of status quo was passed. Full stop. It is submitted that the petitioners are still in occupation of the land. Full stop. Para. 3. Kotoki, the learned counsel, has also informed this court that in the meantime, the respondent number 8 has instituted title suit 479 of 2023 in the learned court of the civil judge, senior division number 1, Kamrup within bracket M, for, amongst others, a declaration of right, title, and interest and recovery of khas possessions, including eviction, and the present petitioners are contesting the suit. Full stop. He has submitted that unless the rights, inter se rights of the respective parties are determined by the appropriate civil court, the petitioners cannot be forcefully evicted from the land in question. Full stop. Para. 3. And us, Learned State Council, has however raised a preliminary objection on the maintainability of the writ petition by contending that the petitioner number 1 association is not a registered association, and therefore there is a legal bar for institution of the present case. Full stop. He has also submitted that since admittedly a suit has been filed which is pending, the present writ petition has in fact become infructuous and is liable to be dismissed. Full stop. He has, however, candidly admitted that the state has not filed any affidavit in opposition. Para. Miss S. Nath, Learned Counsel for the respondent number 4, has submitted that affidavit in opposition has been filed by her client on date. Full stop. She has justified the action taken on 2/2/2021 as it was done by following the due process of law upon an application for mutation by the respondent number 8. Full stop. She has clarified that since presently the respondent number 4 is under suspension, there was no access to the official documents, and therefore the relevant documents could not be annexed to the affidavit in opposition. Full stop. She has, however, justified the action taken on 2/2/2021 and has prayed for dismissal of the writ petition. Full stop. Para. 3. H. Buragohai, Learned Counsel for the respondent number 8, has endorsed the submission made by the State Council and has objected to the maintainability of the writ petition. Full stop. He has specifically submitted that the petitioner number 1 association has 216 members, and at the time of institution of the present writ petition, the petition number 1 association was not having any valid registration. Full stop. As regards the rest of the petitioner numbers 2 to 5, it has been contended that they have joined the petition on the strength of being member of the association and have not espoused their individual cause, any individual cause of action. Full stop. Para. He has also contended that once the de-requisition was done in the year 1999, the land has to be vested, land stands vested back upon the owner in its original position. And in this regard, he has drawn the attention of this court to section
8(1).
8(1) of the
Of
Act
Assam.
of 1964. Full stop. He has also informed that,
May I read, madam?
no, not required,
Okay.
that This writ petition, which was instituted on 24/3/2021, is in fact a counterblast to the FIR lodged by the respondent number 8 on 23/2021. Full stop. It is submitted that three of the present petitioners were made accused in the said FIR, and based upon the same, sessions within bracket LG case 100 of 2021 has been registered and is presently pending before the learned court of the additional session judge number 1 Kamrup M. Full stop. He has also admitted of instituting the aforesaid title suit in which the petitioners have entered appearance and are contesting. Full stop. The learned counsel has, however, raised a serious apprehension that because of the order of status quo passed by this court, the present petitioners are taking advantage and changing the nature and character of the suit and also creating third-party rights. Full stop. He has also informed that though an application under Order 39, Rule 1 and 2 has been filed in the pending title suit 479 of 2023 for restraining the defendants to change the nature and character of the suit, the same has not been able to be considered in the proper perspective in view of the continuation of the present status quo order passed in the present proceeding. Present status quo, no, status quo order passed in the present proceeding.
My lord, may kindly mention the miscase number. It is 786 of 2023, the injunction application.
Yes, injunction application being miscase number
Miss J case number 786
786
of 2023.
26. Full stop. The learned counsel has submitted that the petitioners are taking advantage of their own wrong, and accordingly, the writ petition is liable to be dismissed. Full stop. Para. Sri Kotoki, in his rejoinder, has clarified that the objection regarding registration would not be a valid objection in view of the facts that the association was already registered, and at the time of institution of the writ petition, the application for renewal of the registration was pending, and this statement was candidly disclosed in the writ petition. Full stop. By drawing the attention of this court to the affidavit in reply dated ... the learned counsel has submitted that in the meantime the registration has been renewed, and it clearly appears from the said renewal that the petition number 1 was enjoying the status of a registered association. Full stop. He has otherwise submitted that the jurisdiction exercised by this court under Article 226 of the Constitution of India is plenary in nature, and the aspect of registration would not be an absolute bar for adjudication of an issue which involves violation of the fundamental rights of the petitioners. Full stop. In this regard, he has relied upon a judgment of the Honorable Supreme Court in the case of Akhil Bharatiya ... reported in AIR 1981, Supreme Court 298, wherein it has been laid down that even an unrecognized association can approach a writ court. Para. The rival submissions have been duly considered, and the materials placed before this court have been carefully examined. Full stop. The undisputed facts which emerge from the materials on record is that the present writ petition pertains to an area of 2 bighas, which is a part of a larger plot of 50 bighas, which was requisitioned in the year 1976 under the Act of 1964. Full stop. Though the purpose of such requisition was for construction of a helipad at Beltola, Guwahati, there was a change in the policy which led to de-requisition of the land vide an order dated 20/12/1999 passed by the Deputy Commissioner Kamrup. Full stop. On such de-requisition, the land had vested back to the earlier owner. Full stop. Sri Buragwan, the learned counsel for the respondent number 8, would be right in contending that under section 8 of the Act of 1964, such vesting of land has to be in the original shape of the land. Full stop. However, it transpires that the respondent number 8 came to the picture only by a purchase of the land in the year 2011 vide a deed registered on 2/8/2011. This court has also noticed that such transfer of land was on the condition that the purchase was made along with encumbrance and the symbolic possession was handed over. Full stop. Be that as it may, comma, from the order dated 2/9/2014 passed by this court, whereby a proceeding under the Public Premises Act of 1971 was interfered and set aside, would fortify the position that the nature of the land is not public land but private land. Full stop. The cause of action espoused in this present petition is which an event which occurred on 2/2021, whereby 2021. So it is the allegation. Please have your seat. Yes. It is the allegation that the respondent numbers 4 to 7 had forcefully entered the land and handed over 2 bighas to the respondent number 8. Full stop. Full stop. The aforesaid action does not appear to be backed by any mandate of law, comma, a full stop. There is nothing placed on record to show that such an action was either in compliance of any order of the court or any lawful authority to make such eviction. Full stop. Though the status of the petitioners appear and rather has been admitted to be that of encroachers, comma, such encroachment being on private land, comma, the same can be removed only by following the due process of law. Full stop. Admittedly, comma, a title suit 479/2023 along with the injunction petition are pending for consideration before the learned civil court. Full stop. Additionally, the land grabbing case is also pending. A land grabbing case being sessions within bracket LG, case number 100 of 2021 is also pending before the appropriate court. Full stop. Para. On the issue of non-registration of the respondent number of the petition number 1 association, on the issue of the objection raised by the learned counsel for the respondents on the aspect of registration oblique non-registration of the petitioner association, comma, this court is of the opinion that the powers exercised by a writ court being plenary in nature, whereby the ultimate objective is to ensure that justice is done, such objection can be treated to be a technical objection only. Full stop. This court, however, hastens to add that if the cause of action is directly connected with such aspect of registration oblique non-registration, the same can be an issue for adjudication. Full stop. However, in cases where the association espouses the cause for its members, such technical objection may not be a valid objection for adjudication of the actual issue before this court. This court has also noted that apart from the petition number 2-1 association, there are 4 other petitioners who are members of the petitioner number 1 association and are also affected by the impugned action of 2/2/2021. Full stop. This court has also noted the settled position of law as explained by the Constitution Bench of the Honorable Supreme Court in the case of Bhailal Bhai, that a writ petition can be moved even on an apprehension. Full stop. For ready reference, the relevant observations are expected herein below, paragraph 15. Full stop. That apart, they said a similar view was reiterated by the Honorable Supreme Court in the case of S.M.D. Pasha versus State of Maharashtra, in which the following observations have been made. Reported in search. Be that as it may, the settled position of law is that an encroachment proceeding, a proceeding for removal of encroachment over private land can be done only by following the due process of law. Full stop. It clearly appears that the action taken on 2/2/2021 was not preceded by any due process. Full stop. The respondent number 4 in his affidavit filed on ... has made a submission that the law was followed. Full stop. However, no documents have been enclosed to the affidavit with the explanation that at the time of filing the affidavit, the said respondent was under suspension and was not having access to the documents. Full stop. The state has not filed any affidavit and no records have been produced, even to suggest that the due process of law was followed before adverting to the action taken on 2/2/2021. Full stop. Under the aforesaid facts and circumstances, this court has no other option but to come to a conclusion that the action taken on 2/2/2021 was not done by following the due process of law and is accordingly declared to be illegal and set aside. Full stop. At the same time, the rights which have vested upon the respondent number 8 by virtue of the unchallenged sale deed dated 2/8/2011 cannot be ignored or overlooked. Full stop. In fact, the said respondent number 8 has instituted title suit as well as a proceeding under the Land Grabbing Act is going on. Full stop. While this court has interfered with the action taken on 2/2/2021, it is made clear that the aforesaid title suit and the land grabbing and the proceeding under the Land Grabbing Act be proceeded with expeditiously and in accordance with law, and following the consequence thereof, the logical steps may be taken full stop. It is made clear that without any order passed by the authority vested with law, comma, the eviction of the petitioners cannot be done.
Yes, ma'am, I'm obliged. Just one humble submission, ma'am, if my lord can add that any findings or observation of this court will not have.
Yes,
any-
yes, it is also made clear that the present order has been passed qua the impugned action dated 2/2/2021 and will not have any bearing on the marriage of the inter se marriage of the respective parties contesting the cases below.
Yes, ma'am. I'm highly obliged, my lord. I'm deeply obliged, my lord.
You can take this back.
Yes, my lord. I'll take it.
Much.
Much obliged, my lord.
Registration of.
And my lord, the order which was passed interim order in this case, my lord, will stand vacated or will be merged with this order.
The interim order stands merged
Yes, ma'am.
with this final order.
I'm obliged, my lord.
Lordship, I am appearing on behalf of Mr. Esnat for respondent number 124. He is not well. Kindly the matter possible.
Yes, yes, your lordship.
Lordship may be fixed for the next week.
Okay. LICI,
Lordship.
okay, while the learned counsel for the parties, for the respective parties are present, comma, a prayer for adjournment has been made on behalf of Sri S. Nath, learned counsel for the LICI, who is stated to be unwell. Para, in view of the above, list after a week.
May I pray for a fixed date, your lordship?
You tell us, in view of the above, matter is adjourned to be listed on, according to Nelekiba, to be listed on 20, is 27th okay?
Yes, your lordship. Highly obliged.
27 October.
Lordship, here in this case, Lordship, further 1 week time is required to submit our affidavit, Lordship.
Okay, notice was issued on the last occasion.
Yes,
Okay, not 1 week, we'll grant you 2 weeks time.
Lordship.
Okay. Your name?
Lordship, Valentina Vilabino-Tanya.
Huh?
VV Tanya.
Okay.
Lordship,
Yes.
there is the interim orders.
Okay.
Looking my very much.
Heard Miss V.V. Thanu, learned counsel for the petition, Apara, on the prayer of Sri J. Goswami, J.K. Goswami, learned
Lord.
standing counsel,
Eh.
HNVT Veterinary Department.
Lordship.
2 weeks time is granted to enable filing of affidavit in opposition. Lords. Interim order passed earlier to continue till the next date of listing.
Much obliged.
Yes.
Make these are Lordship.
Yes, Mr. Alam, what is this?
Yes, my lord. Actually,
Order 2018 matter.
Yes, my lord. Amended cost title, my lord, we have already filed, it is on record, my lord. Now, the issue involved in this case is very narrow in compass, my lord. What has happened, my lord? There was Indo-Bangladesh border fencing was being constructed by the government of
Yes,
India.
who's for the other side?
Yes.
Government.
Government, my lord.
7.
Yes.
Item 7.
Item 7.
Affidavit has been sent.
Affidavit has been filed with the state, my lord, that you cover, they
Yes.
have admitted, my lord, actually.
We'll take this for disposal 2018 matter.
Yes, my lord, my lord.
What is
So,
it?
yes, my lord. My lord, may kindly come to my lord, page, my lord, 37, my lord.
37.
Yes, my lord. What has happened, my lord? While constructing, my lord, that Indo-Bangladesh border, my lord, these peoples have gone beyond fencing, my lord. So state has taken a policy, my lord, under which, my lord, they have been allotted 10 katas, which is equivalent to a half kata of here, my lord. Half kata of land to the 174 families, my lord. So out of that 174 families, my lord, 101 families is before your lordship, my lord.
You were allotted,
Yes, my lord. My lord, may kindly come to page 37.
allotted how much land?
10 katas, my lord,
To each of the families.
to each of the families, my lord. So the lordship may kindly see, my lord, that page 37 is a provisional allotment certificate has been given. The difficulty is that possession was not given to us. That is the difficulty, my lord. That is why we approach before lordship, my lord. So it says, my lord, the certificate says, my lord,
Yes.
for rehabilitations of the 174 affected families, we are still who are still residing outside the Indo-Bangladesh international border fencing in different Inglo-Bangladesh border line mojas. The following schedule of the ceiling surplus land and moja so and so was proposed for allotment in favor of the persons named below. And after placing the allotment proposal before the Subdivisional Land Advisory Committee in its meeting held on 20/2/2016. The committee, under the chairmanship of the Deputy Commissioner Kachar, formally recommended allotment of the proposed land by agenda resolution number 1 as communicated by memo number so and so. So, my lord, name of the petitioner, my lord. So, in this way, my lord, all petitioners, my lord, they have got the certificate, my lord. But while, my lord, giving the possession, my lord, that could not be done because, my lord, there was a stiff opposition from that area, my lord. So, ultimately, my lord, possession was not given to us. So, when we approached this honorable court, my lord, they state has filed an affidavit, my lord. Now, my lord, may kindly come to the affidavit that they have filed, my lord, at page, my lord, running page number, my lord, is 67, my lord.
Yes.
Is para number 15, my lord. So we came with twofold prayer, my lord. One for acquisition of the remaining land and one for this giving it to give us, my lord, that allot us the land, my lord. So now 67, my lord.
Who has filed respond number 9?
Yes, respond number, my lord, 9, my lord. So I read, my lord.
101. Yes. Which paragraph?
Paragraph 15, my lord.
15.
15, my lord.
Yes.
So they said, my lord, with regard to the amendment made in para number so and so of the repetition, the department reiterates that the proposal for rehabilitation of 7 families out of 174 families has been submitted to the Director of Border Protections and Development on 30/11/2023.
Yes.
Meanwhile, efforts are ongoing to identify suitable land for rehabilitating of remaining 167 families. It is also found from the record that out of 104 petitioner in the instant writ petition, 2 number of petitioners, that is petitioner number 42 and 43 as serial number 2 and 3 of the proposal for the rehabilitation of 7 families have been included in the rehabilitation proposal of the said 7 families. It is further submitted that no instruction was received requiring acquisition of land outside the fence from the concerned department. However, no land acquisition was done. In these premises, it is submitted that the prayer made by the writ petition for resettlement rehabilitations of the petitioner is already on process. But the prayer for acquisitions of the land cannot be entertained as the department concerned has not made any such acquisition for acquisition of the land outside the fence, my lord. So, my lord, now my prayer is, my lord, since we made a, my lord, prayer, my lord, that in our prayer number 1, my lord, we made a prayer that to resettle the petitioner, my lord, at any place suitable, my lord, to the petitioner, considering their social, cultural, and traditional factor, my lord. Prayer here, my lord.
Yes.
Suitable socio-cultural and traditional factor with facilities that has been envisaged in section 32 of the Act of 2013, my lord. So, facility that is required to be given, my lord, for rehabilitation under the Act of 2013, my lord. Considering this aspect of the matter, my lord, the petitioners, my lord, may be resettled, my lord, in the proper way with some specific time frame because they are
Yes,
in the
yes, what
process.
do you
now.
say?
Para number 10, my lord.
Of the,
Page
affi-
6, yes, my lord. Page 65.
of the affidavit, or your affidavit?
Yes, ma'am. 65, running page 65. That. Mary?
Yes, yes.
That with regard to the advertisement made in the para 11 of the writ petition, the deponent beg to state that allotment made to the 174 families in 2016 has not been cancelled. However, as the allotted land could not be physically handed over to the allottees due to the stiff resistance from the local people, proposal for the rehabilitation of the 7 families out of the total 174 families. have
Yes,
been
that same thing Mr. Alam has
Yes, my lord.
reiterated in.
Last line, my lord, last
Yes.
line. Meanwhile, the efforts are ongoing to identify the suitable land for the rehabilitation of the remaining 176.
This was of 6/6/2024.
24, my lord.
More than a year has passed.
Yes, my lord. The present
So,
status.
Present status, you have to take steps. And he has also relied upon section 32 of the 2013 Act,
Yes, my lord.
which talks about rehabilitation.
Yes, my lord. Thirty-one. 32. Provision for structural amenities in relation.
This, apart from the fact that this writ petition is pending since the year 2018,
Yes, my lord.
the first, allotment was of the year 2016 February.
Yes, sir.
Now, it may be a
25.
practical difficulty due to local objection.
Yes,
It could not be finally, possession could not be handed over.
yes, my lord.
But you have to take steps in accordance with law.
Yes.
Engage your law and order machinery and ensure that they are rehabilitated. Because there is no resistance from you on the on their claim in principle.
Yes, ma'am.
You are agreeing, only saying that some process has also been started.
Yes, yes. I mean, out of the 104 petitioners, my
Can
lord.
you do one thing? We'll have it at 2 o'clock.
My lord, yes.
You take a telephonic instruction. If you can. Otherwise, we'll pass orders to consider and pass definite orders within a time
Yeah.
bound frame.
Can it be on Tuesday? On Tuesday.
Tuesday is a holiday, I think.
Uh,
Monday, Tuesday.
Thursday,
Not Wednesday we can have.
Wednesday, my lord.
Wednesday. But get it.
Yes, yes, yes.
This
Yes,
is very
yes,
deep-
yes, yes.
it should not be.
Otherwise, my lord.
It's not a matter where there is stiff opposition. We just need to settle the matter.
Yes, yes.
Heard Sri G. Alam, Learned Counsel for the petitioners. Also heard Sri N. Das, Learned State Council, and Miss L. Devi for appearing on for the Union of India. Para. Okay, Union of India. Para. You're also there, madam. G. Hazarika for the Revenue Department. Para. From the pleadings exchanged, it appears that two of the petitioners, namely petitioner numbers
42 and 43.
42
and-
42 and 43 have been rehabilitated, and in the affidavit dated 6/6/2024 filed by the respondent number 9, there is a clear undertaking for initiating and completing a process for rehabilitation of the petitioners in a suitable location. Full stop. It is also admitted that though such allotment of land was given in the year 2016, as the petitioners were affected by the border fencing, the actual possession could not be handed over due to stiff opposition of the local
People.
persons, local people. Para. As a statement has been made in the affidavit filed by the respondent number 9 on 6/6/2024, Sri Das, the Learned State Council, is directed to obtain instructions with regard to the present status of the process said to have been initiated. Full stop. List. The matter is accordingly adjourned to be listed on, what is the IA?
For substitution, my lord.
Okay.
Because of that,
On
this-
22.
22nd, my lord. My lord, proposal has been made for resettle of this 42 and 43 petition. They have not been rehabilitated, my lord. Proposal has been initiated. by them.
Proposal, my lord.
Oh, not for.
No, no, meanwhile,
That's case, that's the start of-
Not for the petition.
yes.
proposal for.
Proposal for
Bhulo, bhulo.
proposal,
Bhulo, bhulo.
rehabilitate,
Uh,
not
Key for 42, for whom proposal
proposal.
was made.
Yes.
Last year, hin nakoba.
Wednesday, no?
So, goodness.
On the instructions, on the steps taken in the meantime.
Yes, by Wednesday.
Not
But-
timely.
22nd.
Proposal
Oh.
দুটাৰ কাৰণে থাকে, এইটো বহুতটা petition হৈ আছে। আমি normally খুলিছো, বাকিৰ কাৰণে কি কৰিছে? Yes,
22nd, my lord.
22nd.
Obliged, no?
Yeah, please, Lordship. Lordship, on last occasion, your Lordship has called for the report of the Assam Board of Revenue. And as per office note dated 14 of October, that has been not received.
It was admitted for hearing.
Yes, Lordship, but that's because that has been not received, which come under order column. Hearing on a fixed position to order.
Oh. When this matter was taken up for consideration on the last occasion, that is 28/8/2025, this court, by noticing that the same is pending, that this case is pending since the year 2018, had admitted the same for hearing and had called for the records from the learned Assam Board of Revenue, Assam Board of Revenue,
Lordship.
Guwahati, full stop. Office note dated 14/10/2025 has, however, reflected that the LCR has not been received, and accordingly, this matter has been listed in the order column. Para, office to give immediate reminder and requisition the LCR from the ABR, from the learned ABR, and list this case for hearing immediately thereafter.
Lordship, interim order is there.
Interim order passed earlier to continue till the next date of listing.
Highly obliged. Leave it.
Yes, what is this?
Lordship, my last order, Lordship was pleased to direct, work of record was called for Lordship. And we were directed to take justice service upon the respondent number 3. We have.
Yes, Mr. President.
My lord,
Please, my lord.
we have taken steps. In terms of your lordship's last order dated 5/9.
No, have you
Perhaps the
filed the
stand of the respondent number
affidavit has
3.
not been filed for the stay.
No.
Yes, I am for the respondent number 3. I am appearing virtually. Yes, I hope I am audible.
Yes, oh, you are appearing, then,
Please, my lord.
yes, will you like to file any affidavit?
Yes, my lords. My lord, yesterday we had received notice
This
from the
matter,
petition.
though it is of 2023, the rights of the workers is at stake, so would like to enable, definitely you'll have a chance to file your affidavit, but that has to be
Lord-
done expeditiously. How soon can you
Lord-
file the affidavit?
My lords, if your lordships would grant me 4 weeks, considering, my lord, that the next 2 weeks
I
we
think
are
it's a
not.
long time.
In
4 weeks.
2014.
We'll grant you 2 weeks' time.
My lords, next week is Diwali, the office is closed. My lords, in Bombay, there are vacations also. If your lordships would indulge me, my lords, for 4 weeks, my lords, I will be able to.
We cannot grant you 4 weeks. We'll grant you a reasonable time. We'll consider your prayer. Today is what, 16th?
Please, my
16th, we'll have this matter on 4th of November. You get
Very
that
well.
time, okay?
Very well, your lordship.
but file your affidavit invariably before that.
Yes,
And
my
we'll
lord.
entertain you on online, there's no difficulty, but file it through a local council, whoever is there, okay?
Yes, my lord.
Milord, instead of fourth, could it be third, Milord? Fourth, I have a.
Yes, third it
offense
is
of Milord.
possible, third is a Monday, that is why we're trying to have, because we are trying for a
My
final
lordship will have it on sixth, Milord.
sixth is okay. Sixth,
Milord,
Yes.
then, Milord, may I pray for 7th? Milord, my senior may not be available on 6th, who leads me, Milord. 7th
so-
Friday,
seventh.
I'm
Seventh.
most
We'll
grateful.
try.
Most.
And
Seven.
idea is, Milord, that the lordship will.
We'll try to
dispose of it.
dispose of some workers either this way or that way, we'll take a
Yes,
call.
yes.
Okay. Third, Sri K. N. Chaudhary, Leonard Senior Counsel for the petitioner, Senior Counsel assisted by Sri S. Chakraborty for the petitioner. Also heard Sri Mazumdar, Learned F.J. Mazumdar, Learned Counsel for the contesting private respondents. Para. This court, while order dated 5/9/2025, had directed service upon the respondent number 3 by Dusty, which the learned counsel for the petitioner has submitted to have been taken, full stop. Sri, your name, please.
Please, Milord. Advocate Haris Khan.
Sri Haris A. Khan, learned counsel, has in fact appeared to the online for the respondent number 3 and has prayed for some time to file the affidavit in opposition. Full stop. Considering the issue involved, wherein the rights of the workman is sought to be espoused, comma, this court grants time to the respondent number 3 to file its response, and the next date is fixed on 7th of November 2025. The affidavit be filed in advance so as to enable the petitioner to make any rejoinder.
Let it
if-
be filed by first, Milord. We'll file the.
enable the petitioner to file any rejoinder if so advised. Okay.
Most grateful for
Have you filed
indulging
your
me
power,
through this.
Mr. Khan?
No, Milord, not so far because we had received notice
No,
only
no,
yesterday
that-
evening, so we'll do that.
In fact, so has appeared on instructions and has undertaken to file the power as well as affidavit. Okay, that's the issue.
Most grateful.
Deep clear. Okay.
May please, your lordship.
Notice was issued. What is this?
I am
But
the
this is
respondent
for
number 7, Milord.
Election of president.
Sometime may be allowed to file objection, Milord.
Okay.
We have filed affidavit regarding the justice of his affair.
You have entered appearance.
Yeah.
And who will file? Panchayat will also file. Mr. Dotto, will you file affidavit? Is required.
No,
My
you
lord,
have
I
to
think
say
our-
the secondly.
Not required, madam.
Main.
Lordship will grant some time then.
Okay. In this case, notice was issued on 10/9/2025 and Sri. This is item number.
Milord. Respondent number 7, Milord.
Your name is not there, Mr. Ahmed?
A.M. Ahmed.
Oh, it's there. R7.
Yes.
It's there in the call, please. And Sri A.M. Ahmed, Learned Counsel, has entered appearance for respondent number 7. First of all, the department, the PNRD department is represented by Sri S. Datta, whereas Ms. Castor is present for the State Election Commission. Para, on the prayer made by the Learned Counsel appearing on behalf of the respondents, matter is adjourned by 3 weeks to enable filing of affidavit in opposition.
Obliged.
The
Yes.
date may be fixed.
What is the issue?
President for selection of president, election of.
Okay,
No, what
List.
happened, Milord, in this case, Milord, petitioner number 2.
what has happened, you state in your affidavit.
Obliged. Obliged.
The government affidavit will cover.
Yes, government, the deputy commissioner. Milord.
But then H. Sharma also. H. Sharma Nama Hotel first. List on, yes, tell us. To enable instruction and file an affidavit.
27th November, Milord.
Too late.
1, 2, 3,
10
11 on 11th, 10th of November.
10th of
10
November.
November.
Obligation.
Okay.
And obligation.
Lordship, kindly pass over the matter for timing, your lordship. My senior is on legs in court number 23.
Okay, matter is similar. But we'll have it today itself, madam. We'll not adjourn it, okay?
Yeah, pass
We'll
over.
accommodate you for some time, 16 matter, 15 or 16 matter, old matter. Okay. What is the issue, Mr. Chaudhary?
Lordship, they are demanding for making the C form that way defective in the assessment processing, some time for submitting the corrected C form.
But is there any life cause of action existing 2016 matter? Is there any interim order?
Lordship. Yes, Lordship, the proceeding was stopped.
But is there,
And the impugn order was stayed, Lordship,
is it?
as far as I remember, Lordship.
In fact, there was an issue of objection regarding the maintainability of the writ petition. There is no interim order.
Lordship, because they had the alternative remedy before the
Oh,
Board of
yes.
Revenue.
There is no interim order. Is there any life cause of action? Probably not. Check the records.
Yes,
Before Matimoto, maybe after lunch.
yes.
Yes.
Can I make a small prayer, my lord? Can it be on next Wednesday or Thursday?
No. We can grant you time till 2 o'clock.
My lord,
18 matters for him.
my lord, the issue before your lordship is this, my lord, on an apprehension.
Yes, as I have seen, there is nothing in this petition of
But-
eviction or likely to be evicted.
My lord, and only thing is this, my lord, they have stated that they have allotted land to other persons on the same plot of land. They have allotted, that is their affidavit. And they have stated that this government land, I don't have.
No, if there is any eviction, it will be done by due process of law.
My lord, that much, my lord, if any eviction is done,
Yes,
and my lord, that
And you are
on the
protected
basis
by-
of Salahuddin and Arvind.
You're protected by a status quo order, so there's nothing to apprehend.
My lord, and only that, another aspect of the matter, my lord, if any eviction, then my claim for settlement may be considered, that
You
much.
can file an application.
My lord, I will file an application and that may be considered, my lord. That-
Who is R2? Mr. Sharma, you are R2?
Yes, R2 Lordship, we have stated our contention in paragraph 4. It's a VGR land and he was not found in that under position over that plot of land.
And my lord, in para 5, they have stated that they have allotted lands to all these persons. Para 5, and next paragraph, they have said that I don't have any legal right to claim settlement of government or VGL land. This is a wrong submission, my lord. Government land, I have a right to settlement.
Under Vasundhara Lordship, if he is landless, he can apply Lordship.
Okay. So disposal without argument.
My lord, this is the,
This is the craft of advocacy. Do not argue, let the court talk.
my lord, when everything can be
Hmm.
settled
Okay.
without.
Heard Sri P.K. Roy Chaudhary, learned counsel for the petitioner. Also heard Sri H. Sharma, learned additional senior advocate, and Miss G. Hazarika, learned standing counsel revenue department. Please have your seat. Considering the hearing. As per the facts projected, the petitioner belongs to the BPL category and is in occupation of a land measuring 2 katha, 10 lecha, covered by Dag number 8, part situated at Pushim Thaniram Path, PATH, Hojai, wherein he had constructed a small house for his residence. Full stop. It is also the case of the petitioner that there is a grazing reserve in the name of Poschim Dhaniram Path under the Mouza Zagizan in the district of Hojai, which encompasses an area of about 300 bighas. Full stop. The petitioner had approached the authority for settlement
of the land in his favor as the area under his possession has been alleged, has been claimed to be de-reserved. Full stop. It is also the case of the petitioner that similarly situated families who are also landless had applied for such settlement. The grievance of the petitioner is with regard to the inaction of the respondent authorities to bring the aspect of settlement of the land to the petitioner to a logical conclusion. And the petitioner had also apprehended eviction from the land in question. Full stop. Para. This court wide order dated 22/3/2018, while issuing notice, had directed maintenance of status quo till the returnable date. And the state order of status quo. It does not matter. It's not. And the state order of status quo was directed to be continued until further orders, wide order dated 21/5/2018. Yes, anything on to say?
No, Lordship, our contention is that it's a VCR land, so some allotment were given, but the land has not yet been reserved by the government, firstly. And secondly, Lordship, this person is not found under possession of that plot of land.
Sri Roy Chaudhary, the learned counsel for the petitioner, has submitted that consideration of his application for settlement of the land under his possession is a legal right which the petitioner is being deprived of. He has reiterated that the land under the possession of the petitioner has been de-reserved from grazing land, and therefore there is no bar in law for such consideration. Full stop. He has reiterated that by virtue of the order passed by this court for direction of maintaining status quo, the petitioner is enjoying the possession of the land. Full stop. Para. Sri H. Sharma, the learned state counsel, has, by referring to the affidavit in opposition filed on 19/7/2022 by the respondent number 2, has referred to the averments made in paragraph 4 thereof.
5.
4 also.
5 also, Lordship. 5, Lordship, we have stated that has not yet been reserved by the government.
No, that is 4.
No, 4 is regarding it's a VCR land and this person is.
Not reserved as yet. 4. Second paragraph.
Yes, yes.
Paragraph 4 thereof, as per which, in the said paragraph, it has been stated that the land in question is village grazing reserve land, and there has not been
Lordship.
any action of de-reserving the same.
Lordship.
Full stop. He has submitted that there is a clear bar for allotting any land within the VGR land.
Right.
And in this regard, he has relied upon the judgment of the Honorable Supreme Court in the case of Jakpal Singh versus so-and-so. Full stop. He has submitted that if the petitioner applies for settlement of any other land suitable for such settlement, and if the conditions are fulfilled by the petitioner, the same would be considered under the present scheme. Full stop. Ms. Hazarika, the learned Standing Council Revenue, has endorsed the submissions advanced by the learned State Council. Para. Though the petitioner has made a statement that the land under his possession has been de-reserved, the same has been refuted
by the official respondent number 2 in the affidavit dated 19/7/2022, which has been mentioned above. Full stop. For ready reference, the amendments made in paragraph 4 of the affidavit dated 19/7/2022 is extracted herein below. Paragraph 4, page 45. There is no rejoinder affidavit filed by the petitioner. Para?
Me alone, but in para 5, they have said they have allotted that same land to other person.
As regards the allegation that similar lands have been allotted to other persons, in paragraph 5 of the affidavit, it has been stated that though there has been some allotment, the land has not been de-reserved. Full stop. Para? In the case of Jakpal Singh Supra, it has been clearly laid down that Vizier oblique land, Vizier oblique so and so cannot be allotted to any individual as the same is for community purposes. Full stop. For any reference, the relevant observations are extracted herein below. Para? It also transpires that the aspect of de-reservation of the land as claimed by the petitioner has been disputed by the official respondents, and as mentioned above, there is no rejoinder affidavit. Full stop. In view of such position, the aspect that certain land has been allotted to similar situated person cannot be cited as a precedent, as there is no concept of negative equality under Article 14 of the Constitution of India. Full stop. Para? In view of the above, this court is of the opinion that any move for that the petitioner would not have any vested right to claim possession upon the Vizier land, and the state would be at liberty to initiate any eviction process, which however has to be done by following the due process of law and the law laid down by the Honorable Division Bench in the case of Salekuddin versus so-and-so. Full stop. It is also observed that if the petitioner applies for settlement of suitable land under the present scheme for land settlement and fulfills the conditions, the same would be considered, same is directed to be considered by the authorities in the manner prescribed by law. Full stop. Writ petition stands disposed of. Interim order stands merged with the present order.
Obliged. Yes, Mr. Ahmed, what is your matter?
Item 13, Lordship. There's an order, my lord, of this honorable court, order dated 14/8/2025, Lordship. Certain, my lord, report was directed to be, my lord, submitted, Lordship. That whether that is submitted or not. 14/8. That is after, my lord, hard in length, my lord, Honorable Justice, you can, my lord, call for the report, Lordship.
The matter would not be treated as part heard or tried.
Lordship, subsequently it was released.
We'll take it up at 2 o'clock. Go through the records, Mr. Das.
Matter loss. But in this case, my lord, during Zamindari system, Lordship, the petitioner's grandfather, my lord, owned a plot of land, 12 biggest 3 cutters, Lordship, at my lord, Dihi Gwalpara. That now it was Dihi Gwalpara, Lordship. And because of, my lord, disturbance in possession, Lordship, a title suit was instituted, Lordship, in 1974. And in that title suit, Lordship, a decree was passed, Lordship, declaring the petitioner's ownership and possession, Lordship. And that decree was executed, Lordship, by the revenue authorities, and Patta was, my lord, land was converted to Medipatta land lordship. Thereafter, my lord, without any lordship.
Yes.
Thereafter, my lord, the BFO, Gwalpara lordship, instituted title suit lordship saying that this plot of land claimed by the petitioner is forest land and the decretal land is defined plot of land. The learned, my lord, civil judge lordship dismissed the suit saying that no, this is same plot of land. This is that was decreed by the learned civil judge Munship in the earlier case lordship. In
Yes.
the earlier decree was not challenged, my lord, that has attained the finality already. Now, the subsequent suit was lordship in the judgment. The subsequent suit was put in, my lord, appeal before the, my lord, district judge lordship. That was also dismissed, my lord.
Yes.
That was not challenged lordship, and that has also been, my lord, attained finality lordship. Now, my lord, the revenue authority, the deputy commissioner of Gwalpara lordship, my lord, again without any notice, without any hearing lordship, my lord, the patta granted, my lord, in execution of the decree lordship cancelled. The patta holder, my lord, filed a application lordship for restoration of patta lordship. That was rejected lordship. Against that lordship, the now present petitioner, they are substituted lordship. Their father, my lord, filed a writ petition lordship. In that writ petition, my lord, this honorable court remanded the case to pass a de novo order lordship. Now kindly see, and that, my lord, thereafter the order was passed, my lords, saying that the land was, it's a forest land. My land was fallen in the forest area lordship. Now kindly see decree lordship at page 24 lordship. My lord, annexer 3, sorry, annexer 2. Type copy is at page 20 lordship. My lord, schedule of the suit land,
Page
page 20 lordship. Annexer
20.
Yes, lordship.
Yes.
Land use as measuring 12 bighas, 3 kathas situated at Dihi, Gwalpara, Moza, Bolodmari, Gwalpara, Bolodmari under Tozi number 19 of 1968. BS, Mespara, acquired state, which is wrongly recorded in the Khatiyan number 16 part under PS Matia Circle, equivalent to the land measuring 12 bighas, 15 lessas bounded by so and so lordship. Now, kindly see the judgment passed by the Munship lordship. That is at page 88 lordship. My lord, in the additional affidavit, my lord, page 80. Page 80, my lord, issue number 10 lordship is at page 88. Lordship got it.
This title suit 74 of 82
Yes, lordship.
was instituted by your father,
By my lord, yes, lordship.
by your predecessors.
Yes, lordship. Now, issue number 10,
Page
88, lordship. Issue number 10 is page 88, lordship. That was final decision, lordship. In view of, lordship got it.
yes.
In view of decision of issue number 7 and 9 above, the plaintiff is entitled to get a decree for declaration of this title in the suit land and also for permanent injunction spread for him under the fact and circumstances of the suit. I feel that the parties should bear their own cost. Issue number 10 is decided in the above manner. It is ordered that suit of the plaintiff be decreed on contest to the cost. The plaintiff is hereby declared to be the owner and possessor of the suit land. My lord, this is the decree, lordship. Now, against this one, no appeal was filed, my lord. That was put in execution, lordship. And page 53 of the writ petition text.
Yes.
Annexure 7, Lordship. Referring the above, hereby respectively informed that as per report dated 2/6/2006 submitted by the concerned land recorder and after spot inspection, despite 12 bighas of zero kata, 15 lessons land carrying patta number 7, dag number 16, oblique 299, and 16/210 of Rakshini Jangul block is found under his possession. The aforesaid two that has been cancelled by the order dated so and so, dated so and so, in miss case number so and so, land has been merged into government land by tag number 16. My lord, land was converted to patta, my lord, it was cancelled, lordship, without issuance of notice. This was challenged before the this honorable court, lordship. Now, before that, lordship, the appeal title suit filed by the DFO, kindly see lordship at page 24. Everything has been discussed in this judgment, lordship. Start from.
Now that you have said the DFO's title suit was dismissed and the appeal was also dismissed.
Yes, lordship.
Whereafter you say that the patta could not have been cancelled.
Yes, lordship.
Since that suit instituted by the DFO had ended up in dismissal and affirmed by the appellate court, there was no reason for cancellation of your patta. That is your case.
Yes, lordship. Now, in that judgment, it was, my lord, decided that, my lord, the land decreed in favor of the petitioner and the land claimed by the forest authority that it is under the forest.
Same land.
No. Yes, that is the same
Same
land.
land.
But forest authority says it is different.
Different
plot of
land.
land. Now,
Yes, Mr. Google.
Lordship, here the issue is that whether this particular land identified the petitioner as a lordship to have been under his possession earlier falls within the notified boundary reserve forest or not, that has to be ascertained, your lordship.
But for ascertaining that, aren't you required to file either a review or an appeal?
That ascertainment, the honorable court might order
And
it.
that second suit was instituted by none others but the DFO.
DFO.
So if it is a part of the reserve forest, that would have been your foremost and primary ground.
True.
Which is not accepted by the court, appeal dismissed. Thereafter, how do you again contend?
Because as per order 14/2025 of this honorable court, there was specific direction to us to obtain that earlier instruction whether this land as identified a petitioner under his possession earlier falls within notified boundary or not. With the coordinates, your lordship. With the coordinates, they were asked to produce that thing. We already asked them.
I was not asked, lordship.
And further, it was even the allegation, the petitioner that that while he was asked from the land, other person in the vicinity, they were not required to vacate the land. Even that was the allegation. So that two aspect of the instruction we yet to receive. That ascertainment is a simple direction from this court to bring that on record, your lordship.
Which order?
Order dated, your lordship, 14/8/2025.
But that long time has passed. You
No, we have already asked for the report. They'll providing us within a week of time, your lordship.
Matter is of 2018.
Yes, your lordship.
And it is at the stage of hearing. When can you get the?
Within a week, your lordship.
We'll fix a date then.
No.
Okay. Part 3, M.H. Ahmed, Learned Counsel for the petitioner. Third, Sri M H Ahmed, learned counsel for the petitioner, as well as Sri R R Gogoi, learned standing counsel, Forest Department. Full stop. Sri N Das, learned state counsel, is also present. Para. This court wide order dated 14/8/2025 had directed the learned standing counsel, Forest Department, to obtain certain specific instructions. Para. Sri Gogoi, the learned counsel, has submitted that some more time be granted to enable him to obtain the instructions. Para. Considering that this matter is pending since the year 2018, a small accommodation is granted, directing listing of this matter on today is 15th, 16th. We'll have it on 27th,
27th.
27th or 28th, whichever.
Very well, Lord.
28th, Tuesday? Okay, 28th.
I'm highly obliged, Lord.
Obliged.
May I please, your lordship? Lordship, in this matter, we have challenged the order of assessment as well as the order of revision. Thereafter, we went to revision, lordship. Lordship, there was no stay granted by this honorable court, but
Yes.
lordship, they are waiting for the judgment of this court because lordship, there are several cases which are pending before the appellate authority and revision authority for an adjudication of this case on law point. Lordship, I have a small point, only small point. Lordship, I am an exempted unit from payment of sales tax, VAT as well as CST. My exemption comes from lordship industrial policy, which was announced by the government of Assam, Industrial Policy of Assam 2008. Lordship, the industrial policy is at page 39.
Yes.
And tax benefit which has been granted is at page 70.
Yes.
Lordship, it says exemption, VAT exemption.
Yes.
Lordship, all eligible units which manufacture goods in Assam will be entitled to exemption of 99% of tax payable under the Assam VAT and central sales tax, both. Subject to limit mentioned below. Lordship, there are limits given. Fixed capital, Lordship, the Finance Department of Government of Assam shall be the implementing agency for tax incentives. That is important line, Lordship. Finance Department will bring out a separate notification in this regard. So, Lordship, to give effect to this policy decision, Lordship, a notification was issued, which your Lordship will find at page 98. A notification has been issued by the Government of Assam, Finance Taxation Department, giving benefit of tax, exemption of tax, both to the Lordship. Page 98, Lordship.
The notification by the Finance Department.
Yes, your Lordship. This is a notification by the Finance Department. My Lordship, is page 101. Specifically, the central sales tax as well as the VAT exemption which is given.
98.
Page 98 is the exemption notification. 100 is the limits of tax exemption for eligible.
This is taken out by the Finance Department.
Yes, your Lordship, Finance Department. They have issued notification to give effect to the policy decisions of the Lordship. Lordship, point number 3.
Point 3, yes.
Point number 3 is that tax payable. Lordship, I am allowed to exemption from tax payable. So
Yes.
tax payable is calculated.
Point number 3 of?
Of page number 101. 33. 33. Because exemption is from payment of tax payable. But the tax from tax payable, whatever amount is calculated, 99% I can remit, 1% I have to pay to the tax to the government. This is the policy.
Yes.
So tax payable during the return period by an eligible unit shall be calculated as per the following formula. Lordship, may kindly see tax payable will be output tax plus notional tax liability in the central sales tax minus input tax. So VAT as well as central sales tax both are exempted minus input tax.
Yes.
So that will be my tax payable. Accordingly, Lordship, as per the policy and the scheme, I applied for the exemption and I was, Lordship, page number 107, I was granted exemption.
from payment of sales tax as well as central sales tax. Page 107. Aglo Packaging Lordship is granted eligibility for claiming incentives under policy and for claiming exemption. So, Lordship, if your Lordship may kindly see point number 3 in the page number 107.
Yes.
Date of commencement of commercial production is 26/6/2009. And then Lordship may kindly skip to page 108, serial number 9. 108, serial number 9, Lordship. Sales tax exemption oblique remission is for a period of 7 years with effect from 26/2009 to 26/9/2016 of rupees 5,67.54 Lordship. 5,67 lakh is my exemption limit, which I have not Lordship exhausted. This is Lordship 2009 to 2016. My assessment year is 2009-10 Lordship. Thereafter Lordship, this is given to me by industrial department, this eligibility certificate. Certificate of entitlement is given to me by sales tax unit. Lordship, page 109 is my certificate of entitlement. This also says, Lordship, last paragraph, this certificate is valid from 26/6/2009 to 25/6/2016. So during this period, I am exempted from payment of any sales tax, VAT or CST. Lordship, despite me being exempted,
Yes.
Lordship, the order has been passed under Central Sales Tax Act. Lordship, for the assessment year 2009-10, which is at your Lordship will find at page 110. Lordship, this is 10 period is 10-11. Lordship may kindly see in point 4. Point 4 it is reflecting period ending 2010-11. That is my period. So I was during the exempted period, Lordship, they have levied tax. Now the reason they say that I have levied tax on you, because even though you are an exempted unit, Lordship, after this assessment also, I filed an Lordship revision before the revision Lordship before the additional commissioner of taxes. The additional commissioner has given order, Lordship, that will reflect why the reason. Lordship, even though an exempted unit, they say that they have accepted the thing that I am an eligible unit. I am exemptions that been given. They have said.
What is the order passed in review?
Revision, Lordship, page 115.
115.
115. That is the order, Lordship. This will explain, Lordship, why this assessment has been passed. Because the assessment order is, Lordship, not speaking order. Only figures are mentioned. Page 115 will explain.
Yes.
Lordship, page 115,
Yes.
the department says, Lordship, the order will start at page 118. Lordship, in nutshell, I'll say that they have said that you have not given me C form, that is, I will not give you exemption. Now, Lordship, I am saying that the policy as well as the scheme does not lay down anywhere that you have to give C form, then only you will be given exemption. Lordship, there is a section 8.2, I will explain what is C form, Lordship. But first, Lordship, the relevant portion where they said that if you don't give me C form, I will not give you exemption for those portion where you have not given C form. They have given me exemption.
Let us see the C form.
Lordship, C form, section 8. Section 8 of Central Sales Tax Act. Lordship, may I give the...
We have.
Central Sales Tax Act. Book list नहीं दिया था. Lordship, C form is, Lordship, a concession given to me, Lordship, to promote interstate trade and commerce from one state to another. If purchase of interstate, the central government came up with a plan that if I keep on purchasing from an authority outside the state, then I will be given concession of rate of 2% of tax, which I will have to pay, even though my rate of tax in the state may be, Lordship, 8%, 10%, in this present case, it was 5%. So if I purchase from outside dealer, then it will be 2%. So, Lordship, may kindly see section 8.1. What is the concession given? What is C form? Section 8 is 8.1. Rate of tax on the sales in the course of interstate trade and commerce. One says every dealer.
Yes.
Who in the course of interstate trade or commerce sells to a registered dealer goods of the description referred to in subsection 3 shall be liable to pay tax under this act, which shall be 2% of this turnover or at the rate applicable to the sale or purchase of such goods inside the appropriate state under the sales tax of the state tax, whichever is lower. If 1% is there, 1%, otherwise 2% will be there. Now 2 is also important, Lordship. Supposing I don't, Lordship, sell to a registered dealer. This is only when sell to a registered dealer. The tax payable by any dealer on his turnover insofar as the turnover or any part thereof relates to the sale of goods in the course of interstate trade or commerce not falling under subsection 1. Where it is not falling under subsection 1 shall be at the rate applicable to the sale or purchase of such goods inside the appropriate state under the sales tax law of that state. So whatever local sales tax is there, then it will be, otherwise you will get concession. Now for this concession, what is the form which I have to give? 8.4, Lordship, 4, subsection 4. What is the form I have to give to get this 2%? The provision of subsection 1 shall not apply to any sale in the course of interstate trade or commerce unless the dealer selling the goods furnishes to the prescribed authority in the prescribed manner a declaration. This declaration C form, duly filled and signed by the registered dealer to whom the goods are sold, containing the prescribed particulars in a prescribed form obtained from the prescribed authority, provided that the declaration is permitted with the prescribed time and within such further time as the authority may for sufficient cause permit. So Lordship, this is Lordship section 8.4, that if I give C form, they will give me concessional rate of tax of 2%, otherwise 5%. So far as my case is concerned, 5% will be levied. So Lordship, my contention was that because of this, Lordship, they say you have to give me C form. Otherwise, I will not give you. Lordship, then you don't give me a concession of 2%. Give me 5%. Even if 5% tax is levied, that also, Lordship, I am covered because my total coverage is 5 crore and the tax payable is 6 lakhs. So my coverage is there. So Lordship, there is no fetter in the industrial policy as well as the scheme to Lordship not give me concession. Only because F form, Lordship, this is unnecessary. This is Lordship, somehow this concession. They are saying that you will get exemption only if you give C forms. Lordship, this exemption is at for section 8.1, not for Lordship this one. So Lordship, my only submission is that Lordship in this section, Lordship, another section 8.5 may be read. This is Lordship for the respondent. Notwithstanding anything contained in this section, the state government, if it is satisfied that it is necessary to so do in public interest by notification the official gazette, subject to such condition as Ms. Direct, that no tax under this set shall be payable by any dealer having any place of business in the state in respect of sales by him in the course of interstate trade or commerce from such place of Lordship. This is another notification which can be issued by the by respective states. This is Lordship central legislation. So every state has this. So some concession may be given to any state in like Lordship in respect of tea, the Assam government sometimes give. In respect of some special thing, the concession may be given under the central sales tax by way of issuance of notification, exemption, full or partial. This is the section 8.5.
Madam, you have to just try to explain. See, you have been given the certificate of entitlement,
Yes,
and these exercises have been done in terms of the policy of 2008 to give incentives.
Yes, Your Lordship.
Now you get incentives of tax benefits under clause 7.1 on VAT exemption, which this case is hovering around. And the finance department has brought out a separate notification on 3/11/2009.
Yes, Your Lordship.
As per it, you are claiming entitlement.
Yes, Your Lordship.
And in fact, the certificate has also been issued to you, declaring you to be entitled.
Yes, Your Lordship.
Now, your stumbling block is that you have not submitted the C form. C form
For
is
some
nothing but 8.4 declaration. 8.4. Now, how is it connected?
Lordship, that is what they are saying, that this exemption even though industrial policy is there, exemption is given in their affidavit also they have stated, even though you have been given exemption, but if the exemption, but the exemption will be given under CST only if you produce C form.
Now, what is the connection?
Lordship, connection, Lordship, they are saying section 8.5. Section 8.5, they say that partial exemption or any exemption will be given only subject to 8.4. So they are saying that act will be above industrial policy. And
What is your difficulty to submit the C form as per
Lordship,
8.4?
at that point of time, Lordship, some dealers could not give me C form. So Lordship, I was not able to submit. So Lordship, as on today, my submission that's because now I cannot get C form, Lordship. Now that things are over. Even if I cannot give, my submission is that even if I cannot give C forms, levy maximum tax on me. And then out of that tax, Lordship, that is exempted, that I am covering. I am covered under the, because Lordship, I did not, Lordship, I have asked for concessional rate of tax from them, that you give me only this much amount as concession. They are saying, no, your liability to tax will be more, not 2%, but 5%. So give me 5%, whatever amount is there. My total thing is covered. Lordship, there is a statement, Lordship, if your Lordship will see at page 118, a statement is there that my coverage is 5 crore. So 6 lakhs is also covered. If you are levying additional 6 lakhs on me also, that is also covered under this. Lordship, Lordship, now the main contention raised in the present revision petition is that assessing officer ought to have granted 99% remission of tax payable amount eventually determined by him under the CST assessment by transferring the same to VAT amount. Since it being an eligible unit under the 2009 scheme, was entitled for remission of 99% payable, both under VAT and CST. The available monetary ceiling of exemption for the year 2010 was rupees 5 crore 76 lakh, which was sufficient to cover. Even if they say that no more tax will be levied to you, okay, levy more tax and then also you cover me. Why are you saying that no, only 2% for concessional rate you will have to give me C form? I could not give C form, Lordship. That is a admitted position of fact. His C forms I could not give, and only in respect of those transactions in which I could not give C form, they have levied tax on me. Resorting to section 8.4 and 8.5 of the Central Sales Tax Act, saying that you will.
Yes, what do you say, Mr. Chaudhary?
Lordship, may kindly take up the rate petition page 98.
98.
Lordship, the exercise of power in the first paragraph, Lordship.
Yes.
In exercise of power conferred by subsection 1 of section 54 of the VAT Act and subsection 5 of section 85 of the CST Act, the Governor of Assam is hereby pleased to notify the Assam Industries Tax Exemption Scheme 2009, hereinafter referred to as the scheme for granting exemption partially to such unit which manufacture goods in Assam in the manner hereinafter appearing, namely. Lordship have seen that the exercise of power by the state to fulfill its object under the industrial policy was under section 8.5 of the CST, and Lordship has just read section 8.5. It's in the public interest, and there also Lordship it specifically states that the exemption will be given subject to fulfillment of section 8.4, and 8.4 is the C form, Lordship, that acknowledges that there was interstate sale. The receiver and the giver gives that acknowledgement. Unless there is some document proving that the sale has taken place, authority cannot grant exemption. Lordship, 99% exemption will be there only subject to fulfillment of other conditions of the Act. Here, Lordship, at no point of time, either in the assessment proceeding or in the revisional proceeding, they made a petition for extension of time as required under Rule 12.7 of CST, nor any document was produced that subsequently I have received the C form of the necessary amount. That was not produced before the authority. So authority has to make the assessment since they were unable to produce it, and adjustment with the monetary ceiling. Lordship, that 5 crore something that was given in the
Yes,
entitlement.
that is what the submission is.
Yes.
Even if 8.4 and 8.5 says that you have to fulfill it, it will operate only on fulfillment of 8.4.
Yes, Lordship.
And 8.5 is specifically mentioned in the notification dated 3rd of November 2009, which you have just placed reliance upon. Now, the submission is that even if you do not fulfill this, the limit which has been given by the certificate of entitlement would be of an amount which will easily cover the present amount. That is what the submission is.
Lordship, on that point, I would like to submit that also has connection with section 8.4. Since there has to be a notification that it will be made adjustment with the monetary ceiling. And for that purpose also under 8.5, there has to be a notification so that they only on fulfillment of section 8.4, they can claim that for adjustment with the monetary ceiling, Lordship. At no point of time there was any submission before the assessment authority or the revisional authority, Lordship. And Lordship, the assessment cannot wait till they produce it because there is a limitation will also come into play. So assessment has to be made since they were unable to produce the C form.
Lordship, I have made the submission.
Oh, we'll come to you. You said that C form is a must.
C form is a must.
Only from C form you are able to ascertain
That
the
sale
transaction,
actually,
sales transaction.
yes, Lord. Then only they will come within the purview of the exemption scheme to claim for the
VAT exemption.
Yes, Lord. First, there has to be some document to prove that interstate state sale has been made.
Interstate sales, local.
And Lordship may kindly peruse Rule 12.7
of
CST. If Lordship is having this book, it will be in page 38.
Which rule?
Rule 12
of
Lordship, CST registration and turnover rules 1957. Lordship, Rule 7. The declaration in Form C or Form F or the certificate in Form E or
Rule
Form
7.
Yes, fine.
Where are
Rule
the-
12, Rule 12, Sub Rule 7, Lordship.
12.7.
Yes, Lord.
Yes.
The declaration in Form C or Form F or the certificate in Form E1 or E2 shall be furnished to the prescribed authority within 3 months after the end of the period to which the declaration or the certificate relates, provided that if the prescribed authority is satisfied that the person concerned was prevented by sufficient cause from furnishing such declaration or certificate within the aforesaid time, that authority may allow such declaration or certificate to be furnished within such further time as the authority may permit. There was no such application either in the assessment proceeding or in the revisional proceeding. And here, Lordship, their period was till 30th of June 2011. If that 3 months is taken into account, Lordship.
Yes.
My submission will be that, Lordship, since they were unable to produce the C form for the deficit transaction, Lordship, they are not entitled for the exemption, and until and unless there is the C form, it cannot be adjusted with the monetary ceiling, whatever tax demand the authority has made.
See, madam, 8.4 is directly related to 8.1. 8.1 envisages a situation of interstate sale to a registered dealer, and where the rate is also prescribed 2% of the state, whichever is lower. And if you come to 8.4, it says that the provisions of 8.1 shall not apply to any sale in the course of interstate trade unless you form this declaration. Now, you don't have the declaration.
No, I don't.
Now, if you do not
I
have the
cannot have.
declaration, you do not, why you
That-
cannot have?
At that point of time, I could have, Lordship.
No,
But
you-
now
why-
you cannot.
No, now you cannot, but at that point, why did not you have? How do you establish?
Lordship,
To claim an exemption, first you have to establish on fact that your only certificate of entitlement will not be the certificate is only to hold you eligible to get the exemption. But after being declared as eligible, eligibility is only from the date of commercial production, whatever. Now you have to fit into the facts.
yes, Your Lordship.
If you are not fitting into the facts, how do you claim the exemption?
Yes, Lordship. I'll explain, Lordship. Firstly, Lordship, that 12.7, Lordship, whatever submission has been made, Lordship, there are hundreds of judgment of Supreme Court. Since I am not onto that, I will not submit hundreds of judgment of Supreme Court. Even at the High Court stage also, we can submit C form. Since I cannot now, because the act is no longer there, last 8 years, Lordship, I'll again take your Lordship to section 8.2 first. 8.2, section 8,
Yes.
subsection 2.
Yes.
Lordship, it is not necessary that I'm doing an interstate sale only by a concessional rate. I don't want a concessional rate. Then 8.2 is applicable, Lordship. 8.2. 8.2, Lordship will kindly see
Tax payable by any dealer.
on his turnover. Insofar as the turnover or any part thereof relates to sale of goods in the course of interstate trade of commerce not falling under subsection 1. If I don't fall under subsection 1, shall be at the rate applicable to sale or purchase of such goods inside the appropriate state under the sales tax law of the said, then they will transfer me to the VAT Act. That is what they did not do. And Lordship, the submission that I have not submitted this before the authority, that is not correct. Lordship will kindly see at page 118, the order of the revisional authority itself reflect that I have submitted this before the authority. That since I don't fall under 1, transfer me to 2. Lordship, 118, last paragraph. Last paragraph. That was my main contention.
Yes.
Now, the main contention raised in the present revision petition is that the assessing authority ought to have granted 99% remission of the tax payable amount eventually determined by him under Sales Tax Act assessment by transferring the same to VAT. Because CST exemption is not able to give me transfer to VAT as per section 8.2. Sales tax account. Since it being an eligible unit under the 2009 scheme was entitled for remission of 99% tax payable both under VAT and said CST. The available monetary ceiling of exemption is also also rupees 5,700, which was sufficient to cover if they transfer me to VAT. This is what I have asked them to
Then
do.
what is the
And
answer?
That is the answer. 8.2, I have asked them to.
Then what is the answer then? This is.
Lordship, the petitioner although makes an argument that he was neither given full time for so and so and with an opportunity to remove the defects of so and so covering price of so perceived by the assessing authority, he has neither produced the balance required C form during the revisional proceeding nor has pressed the matter for removal of defects. The superintendent of taxes on the other hand has defended the assessment on the ground that CST liability of us transferred to VAT. They have already transferred some liability to VAT, not all. This could have also been transferred to VAT. Remission account by the dealer in annual tax remission. He could not have transferred higher quantum of central sales tax liability to tax remission account on his own motion. But here I have prayed, they could have transferred. Be that as it may, it appears that both the petitioner and assessing officer have somehow failed to consider the correct position of applicable law, which is that no exemption or partial exemption on tax payable for interstate sale affected to unregistered dealer or the interstate sale not conforming to the provisions of 8.4 of CST would be available as per detailed discussions made herein above. Any proposition that since the Assam Industrial Tax Scheme has conferred the benefit of concession on payable tax both under the VAT and CST subject to a ceiling monetary quantum and a fixed duration, concession in payable tax on interstate sales should be availed independently of the provisions of 8.4 of the Act is outrightly fallacious and misconstrued. as regards the unsubstantiated claim of exports, Lordship, thereafter she is talking about export sale. Since the authority, Lordship, this is the normal position. Normally, Lordship, they have, when I ask for anything, they can do. The assessing authority could not transfer this because I did not ask for it. But before the revisional loss authority, I asked for it specifically, that please transfer the rest of the account to VAT. And it can be possible since assessing officer has done it. And she has not overturned it, even though she has given her some submission, but she has not overturned it. She is saying that no, since no order prejudicial to the petition can be passed, whatever the revision petition is disposed of by rejecting the same on merit. She did not pass any order against the petitioner in respect of the amount already transferred to VAT. So this is a normal position as per 8.2, that normally the amount is transferred to VAT if suppose CST is not covering. So I had asked for it, Lordship, as per page 118, last paragraph, I had asked for it that you transfer it to VAT. Lordship, that was disallowed. The Lordship and Lordship had seen one paragraph that the assessing authority has already transferred some of the amount to VAT already, which he has retained. She did not set it aside. Lordship, shall I read paragraph 119, second paragraph once again for my satisfaction?
We have read this.
Yes, Your Lordship. He could have transferred higher quantum of CST to tax remission account.
But
Okay, so-
why is this that it cannot be done at his own motion? How is this finding?
Lordship, this is the stand that they cannot do it their own. I have to ask for it. I have to ask, even unless and until
But
I
so
ask
far
for
as
something.
so far as 11,59,000 is concerned, what has happened to that?
I had asked for it, so he has transferred it.
And the rest?
Rest, Lordship, since he says that because I did not know that he will, Lordship, without C form, he will not allow me. I did not know. Rest.
And
he
what was the
submitted.
ground for you to ask for a specific amount of 11,59,305?
Because he said that it was defective C form. I said, okay, transfer it to VAT. He allowed it. But so far as the balance C form, defective C forms were there, Lordship. I said, if it is defective, transfer me to VAT. He has transferred it. I have to, my own motion, I have to say that please give me. Unless and until I pray for it, Lordship, my prayer should be there before him. And Lordship, before the revision authority, I made a prayer, but Lordship, that was not accepted.
Defective C forms and no C forms.
Yes, there are two.
Those would be two different, they'll have different ramification.
I said, transfer me to VAT. He transferred it. Secondly, he did not allow the balance because I did not ask for it. I have to ask for it, Lordship. Lordship, like when we do a petition before the High Court, unless and until I plead before your Lordship, Lordship will not grant something unless there is the prayer. The same way, Lordship, unless until I ask for it, he will not grant it. But Lordship, that I have rectified by asking before revisional authority. I asked it before the revisional authority, and revisional authority, Lordship, since it is a Lordship continuance of the assessment proceeding, he could have granted me. And that's a Lordship, with this paragraph, they have shown that it's a regular process. It can be transferred to VAT. And the assessing authority himself said that he could not transfer because I did not ask. There is no other reason.
Now, if you again come to 118, the main contention
Yes, Your Lordship.
raised in the present revision petition is that the assessing officer ought to have granted 99% remission of the payable tax amount eventually determined by him. Where is your prayer to this revisional authority?
Lordship, by transferring the same to VAT, this is the prayer, Lordship. He has written he has reiterated my thing by him under CST by transferring the same to VAT.
Where?
Lordship, payable amount eventually determined by Lordship this same line. 99%
The
of
main
the
contention raised in the revision petition is that the
Assessing
assessing authority,
ought to have granted 99% revision of
that is your grievance. That
Yes,
is
sir.
not your asking before the revision authority.
Lordship is thereafter, it being eligible under wise entitled. Available monetary ceiling of exemption for the year was so and so, which was sufficient to cover 99% of liability. Lordship, when I'm submitting this before the authority, I'm asking the authority to do the same. Lordship, that may Lordship be very technical, and I think so, Lordship, this
Petitioner although-
this may be read as asking this before the authority. Lordship.
Then you have to overcome the observations at 119, the first paragraph itself. It is eligible unit under so and so and entitled to remission so and so, both under VAT and CST. Available monetary ceiling of exemption for the year was so and so, which was sufficient to cover 99% liability under VAT and CST of the year. Petitioner, although makes an averment that he was neither given further time to furnish balance sheet forms. See, this is the balance sheet forms. Nor was provided an opportunity to remove the defects in the 15 number of C form covering so and so. Perceived by saying he has neither produced the balance sheet forms during the revision proceeding, nor he has pressed the matter of removal of defects. So even in the revision and code, where you had gone, where you were you had an opportunity to either produce the balance sheet forms or remove the difficulties, you had not done so. That is the finding of facts.
Lordship, Lordship,
And so far as the second submission is concerned, so far as the defect is concerned, defect number 15 numbers of defective C forms, a stand has been taken. But if there is no C form, can you identify a situation to be, can you equate a
Lordship,
situation?
this defective, and there are some in the defective 11 lakhs 59,000.
Yes, that has been done.
Lordship, that
So how
not,
do you
not
equate?
Lordship, this covers not only the defective. There are some C forms I could not have been produced because the dealers who have sold were unregistered dealers. The C forms I am only asking for that the balance C forms I am asking for only in respect of which I had not asked, because I was thinking my dealers will give my C forms to me, but Lordship, they eventually failed to. 11 lakhs will not cover. Lordship may kindly see that my total defective C form is 46 lakhs. 46 lakhs, if Lordship 5% tax is calculated on that,
Yes.
Lordship, it will be only 2 lakhs something. It is 11 lakhs which they have allowed. So there are some C forms I am sure I am not going to get. That also I have asked him to transfer to VAT, that he have transferred. Apart from those 2 lakhs, rest 5% of 46 lakhs will be, Lordship, some 2 lakhs or 3 lakhs, some odd amount will be there. This is not only defective, and some C forms I will never get, because the dealer to whom I have sold he has transferred it to VAT. This is what I have not asked for, Lordship.
No, this 46 is not only for the defective C forms.
Yes, Your Lordship.
It is for both. Kindly read the entire line.
No, Lordship, for Lordship, if I'll show the
No,
from the assessment order.
please read the fourth line in page 119.
Yes, Lordship, the
The
petitioner.
petitioner, although makes an averment that he was neither given further time for furnishing the balance C forms, nor
98 lakhs.
nor was provided an opportunity to remove the defects
In
in the
the-
15 numbers from covering sales of rupees so and so.
Proceed with. Lordship, this is the defective amount. Lordship, from the assessment order also, it will be clear that 46 lakhs is the defective and rest is the C forms. Lordship, from the assessment order, if your Lordship will kindly see, that is more clear. Assessment order, Lordship will kindly see at page 111. My total C form was 5 crore 34 lakhs. Lordship will kindly see page 111.
Yes.
Books of accounts tally with against the claim of sale of to registered dealer, the dealer is required to furnish C form for rupees 5 crore 34 lakhs. Lordship, 11,000 something, 1 lakh something. Against that, the dealer has furnished 4 crore 36 lakhs 12,073 I have furnished. C forms verified as well. 46 lakh 61,000 found defective, and as such rejected. Rest amount of C form for rupees 3 crore 89 44 760 found in order, and as such accepted C form. There is also short receipt of C form of 97 lakh 89,027 and rejected C form sale of 4661 taken as sales to others and assessed to tax at 8%. So there is 97 lakh and 46 lakhs. 97 lakh is the short receipt of C forms and 46 lakhs is defective C forms, Lordship. From here it is clear, Lordship.
How is this 11 lakh calculated?
Lordship, this 11 lakh, Lordship, on the basis of observation, sales are determined as below. Lordship, 1, 2, 3, 4, 5. There are 5 points are there. So all these, Lordship, since 2% sales to registered dealer, 3,89 lakhs, that is waived completely. Rest is Lordship taxable, and the next page.
No. We are concerned with this.
Next page, Lordship.
No, not next page. The page which we are just reading. At page 119, 1159,305. How is it calculated? From where?
Lordship, this is what I would ask for. Yeah, Lordship, it is calculated at page 112. My total tax assessed is determined as 16 lakh 14,328, out of which CST liability transferred to VAT account is 11 lakh 59,305. Balance tax payable is so and so under CST. So my only was that it could have also been transferred to VAT account. They say that on your own motion I cannot transfer. You have to ask for it.
I will transfer to VAT account. 5%, 2%. Yes. This calculation, Mr. Chaudhary, you have not understood at 11112.
Lordship, it is not discernible as to how the 11,59,000.
30. There is this figure, CST liability transferred to VAT account. Now, Madam says that even if you take into account the defective C forms, which is for an amount of 46 lakhs odd, 5% would not come to 5% or 2%.
Yes, it was 5%.
5% will not come to 11 lakhs 59. So some other amounts have also been included. Now, what is the other amount? From in page 112, you also get 11 lakh 59,305 from below the fourth.
Yes, ma'am.
Lordship, I think so, so Lordship, it can be clear from page 118.
118.
Yes, Lordship. As I told Lordship, some I have sold to unregistered dealer. Lordship will see there is a chart, sales to claimed registered dealers, sales to unregistered dealer. There is a chart, Lordship, small chart.
Yes.
In the sales to claimed registered dealer is 5,23 lakhs excluding 2% tax. Sale to unregistered dealer, Lordship, if 22 lakh 44,466 is taken at the rate of 5%, it comes to 11.
It comes to?
I think so. I think so. It comes to 11 lakh. Calculator. Give me calculator. I think so. This is 11 lakh. 22 lakh 44,466 excluding 5% tax. 11 lakh. Oh, sorry, Lordship. No, it will come to only 1 lakh 12,000. Yes, it will come to only 1 lakh 12,000. Not. Here also it is written, Lordship, the assessing of the transferred liability of 11 lakh 59,305 at page 118 to VAT account for the purpose of allowing 99% exemption thereon, since the petitioner was a holder of entitlement certificate under Assam Soil and has transferred only the same amount in his annual wealth return in so and so in the scene. So
What is 99% of?
Lordship, that is the thing. Lordship, the exemption is allowed, this is the way of allowing exemption, that 99% I will remit with me of whatever
Understood.
tax amount, and 1% I will pay to the government. Whatever tax amount I will determine, 1% I will pay to the government and 99% I will remit. This is the exemption, Lordship. So that, Lordship, people file their returns. Otherwise, government will never know that, they will think 100% they have remitted. Lordship, my submission is that, Lordship, from the reading, it is clear that it can be transferred to VAT account. It is not what they are saying that it cannot never be, it can never be granted. It can be transferred to VAT account, Lordship. Once I'm an exempted unit, it can be transferred to VAT account and I can be granted the exemption of.
But
exemption,
the
Lordship.
entire notification of the finance department takes into consideration 8.5.
8.5, Lordship,
The
under CST.
notification, notification of 3/11/2009 is based on 8.5.
8.5 by section 54 also of VAT Act.
54, yes, but 8.5, and if you take into consideration 8.5, you cannot ignore 8.4.
Yes, sir.
Because 8.5 is dependent on 8.4. 8.4 talks about the declaration, C form.
Declaration, Lordship, it talks about declaration.
Now you're trying to make out a case that even for, apart from the defective C forms, it appears that certain amounts have also given to you because even on where no C forms are existing.
Yes.
So why not the entire?
Why not the
since-
entire? Lordship, this is a regular practice because, Lordship, declaration for C form will be give when I will give, then I will be granted 2% concession. That is why section 8.5 says subject to section 8.4. It doesn't say that 8.4 has to be fulfilled. Then only I will grant. That is not the
No,
case,
no,
Lordship.
no.
Otherwise,
There is.
Lordship,
There is. You kindly come to 8.5.
Lordship.
There is. The 8.5 starts with a non-obstante clause, notwithstanding anything contained in this section. That means 8. State government may. What is there? May on the fulfillment of the requirements laid down in 8.4.
By the dealer. Lordship, may on the Lordship. Lordship, the provision of subsection 1 shall not apply to any sale in the course of interstate. Section 4 says the provision of subsection 1 shall not apply. So, Lordship, it is only saying that one.
Where are you reading? Which?
Lordship, 4. What 4 says, Lordship?
Yes. Provision of subsection 1 shall not apply.
Shall not apply,
To,
Lordship.
shall not apply to any sale in the course of interstate trade or commerce unless.
Lordship, unless declaration C form is
Unless
given.
declaration.
Lordship, but
So if you are trying to take advantage of 8.4, you need to give a declaration.
I'll have to give it. But Lordship, here I'm not trying to take. I'm trying to take advantage of 8.2, which says that if I am not, if by any means I am not able to give 8.1, transfer me to VAT, which the authority has done.
That will be enlarging the policy. The policy.
Lordship, the policy is silent.
No,
on this
policy gives the power to the finance department
to issue
notification.
Give effect to the
Notification is issued on the basis of 8.5. That is the premises on which the notification has been issued. So your submission would be like enlarging the policy,
Lordship,
which
Lordship, but normally, Lordship, now what they do is that if Lordship,
if exemption statutes are to be given constituted in a strict manner.
Lordship, but now
Because paying is the rule, non-paying is the exception. If you are covered by a policy of notice policy, then you have to fulfill the condition.
Lordship, I'll kindly give you 1 minute to explain. Lordship, they say that if I don't give C form, I will not be able to prove my interstate transaction.
Yes.
And then that is the purpose of C form, and therefore, Lordship, if I'm not able to prove my interstate transaction, then of course it's a local sale, Lordship. It has to be considered as a local sale, and VAT has to be transferred to VAT. That is what the assessing officer does. My Lordship, my case cannot go beyond what has been Lordship contemplated by the officers. Lordship, the officers have only not granted to me because I have not asked for it. That is the only reason for which. Otherwise, they have transferred other to VAT, and that has not been Lordship Lordship reversed by the provisional authority.
Then in that case, you have to make out a very specific case from the materials available on record that this amount at page 118, no, not 118,
112.
119, that 11,59,305, you have to explain this. Irrespective of the defective C form,
I have to Lordship file an affidavit to the regard. Lordship, may keep the matter parted after Diwali, Lordship. I'll file an affidavit to that regard with all the figures and figures that this this contains C form also, Lord. The transaction in which I could not give C form, and I knew that Lordship the unregistered dealer.
see
in that would be
the
giving C form.
amount covered by the so-called defective 15 numbers of C forms, we have that amount.
Yes.
46, 61, 436.
Yes, Lord.
How do you then derive 11,59,305? What is how is it derived? 2%, 5%? It is not coming.
Lordship, because I have not given C form worth rupees, Lordship. Lordship, I will file, if your Lordship will allow, I'll file some
60
addition to
matter,
that.
60 matter, we're closing
Lordship,
this.
Lordship,
We're closing this, we'll examine this.
Lordship, my only submission will be that, Lordship, we cannot go beyond what is, Lordship, the assessing officer has held. Assessing officer has already given me concessions of 11 lakh. So, and saying that I could not give the balance because he did not ask for it. Lordship, that line has to be given a meaning that this is the stand of the assessing officer. Lordship, my case cannot go poorer than that, Lordship. Since he has already allowed me some because I have asked for it. So for balance, Lordship, at least Lordship may give a consideration that for the balance, Lordship, to be transferred to VAT, since I have not asked for it. So Lordship, when before the revisional authority, when I have made a specific statement, it may be considered as that I have asked for it. And Lordship, my the same which has been given for 11 lakh, the same consideration may be given for the balance. That will be my Lordship submission. Because Lordship, the Act also says 8.2. CST Act says when CST Act, Lordship, the section itself says that 8.2 says that if you cannot give C form, go to, then it will be transferred automatically to VAT. Automatic. So Lordship, 8.2 is also to be given a meaning. So once I am transferred to VAT, Lordship, then under VAT I am eligible. But if 8.2 cannot be declared redundant, that will be my submission, last submission. 8.2 has also to be given a meaning. If 8.5 has to be given a meaning, 8.2 has also to be given a meaning.
Okay. Look for this. We'll consider this and Haveli. We should be standing consider finance taxation. Against consider judgment.
But if I get any judgment on this issue, I will tomorrow morning I will give to the
On which issue?
on in this issue. If any judgment, if I get
Now, which particular issue?
Lordship, this C form and Lordship, because I remember I have seen some judgment from Bombay High Court on this issue, which says that C form is not necessary, Lordship. Today, Lordship, today only I came from outside, Lordship, so I could not bring that judgment, Lordship. I'll give the judgment, Lordship, in case.
If you can kindly give it tomorrow morning itself.
Yes, Your Lordship.
Okay.
Much obliged. Much obliged.
Yes.
May it please your lordships. My lord, this restitution is of 2023 lordships. Lordships, though pleadings have been completed, lordships, I have to get some instructions that recently this petitioner has paid some taxes to the Gaon Panchayat lordships, and those documents request to produce before the honorable court. Because lordships, I come under the 32 Harapur Gaon Panchayat lordships. Lordship, may I pray that I be taken up in next week lordships?
Yes,
Any
what
day
is-
lordships.
What is this?
I'm just placing one order, Lordship, in the instant matter, Lordship.
No, no, we have not understood what is the what is the effect of making payment, taxes payment to Dharapur
They're
government?
saying that the permission was granted by the respective Gaon
No, but
Panchayat.
it is outside the purview of Guwahati Municipal Court. That is what the
According-
contention is.
Definitely, it is outside Guwahati Municipal Corporation, but it
Yes.
is under GMDL, Lordship, within the master plan area.
Okay. So that will not have any effect.
Yes, Lord.
What did you want to submit?
Lordship, 24/7/2023.
Order dated
Yeah, 24/7.
24/7, 2020?
3.
Yes.
Just one paragraph, Lordship, paragraph 11.
Yes. Yes.
In fact, Lordship, nothing remains, Lordship, thereafter, Lordship. We are not proceeding only because of the pendency of the case, Lordship. Nothing else.
Now, did you remove the illegal construction?
No.
Lordship, this paragraph number 12 may also go through lordship. Paragraph 12, 11 and 12 lordship to be read.
Until they shall not proceed with demolition. Without the there will be no bar to proceed. After 11:8. Yeah, after 11:8, there is no bar.
Lordship,
If you have not removed the encroachment or illegal setbacks, after 11:8, they could have proceeded.
lordships, first of all, I do not come under the GMDA lordships.
Now, this order is not put to challenge, Mr. Sharma, that we will not accept.
Lordship, that original order which is.
No, order of this court, you have not gone before the division bench.
Lordship, it was not filed, lordships.
If you have not filed any appeal, that means you have accepted this, you have undertaken. In fact, there is a specific order of this court directing you to remove the illegal setbacks by 11/8/2023. If not done, GMD will have the authority.
Lordships, I come under the Gaon Panchayat lordships, not under the GMDA lordships. That is the jurisdiction to be seen, lordship.
That will be too late in the day to consider. You have accepted this order, which was passed on the motion date 24/7/2023.
The show cause notice and subsequent order which was passed against me, lordships, it is under challenge before its honorable court, and still that writ petition is pending, lordship. And also, lordship, recently, as I have paid some revenues before the Gaon Panchayat lordship, matter.
No, but your paying of revenue will not have any relevancy. This comes under the GMDA.
Lordship, I do not come under the GMDA lordships. Because GMDA is entirely separate, entirely different, and lordship.
Sharma, unless you challenge the findings of this court in paragraph 11, how can you make this submission before a coordinate bench? You should have filed an appeal before the division bench. This is the finding of the court which has attained finality. In view of the specific drawing disclosing the setback, court is inclined to observe that it will not be open. It will be open to the petitioner to remove this so and so with the next returnable day. If not, they will take action. Matter ends there.
And importantly, Lordship, if Lordship comes to page 80 of the writ petition, Lordship, one so cause was issued under section 87, Lordship, wherein he filed one reply also. But this was not the ground, Lordship.
Lordships 87 and 88 of the GMDA Act, especially Lordships 88 of the GMDA Act, Lordships, that when notice is to be issued, Lordship, they have issued the notice to me, Lordships, and I have given the reply, Lordships. Thereafter, Lordship, they should have given opportunity of hearing, Lordships.
that opportunity of hearing was not afforded, lordships, and it was clearly stated in section 88 of the GMDA Act, lordships. And also regarding these, lordships, I have some judgment of the Honorable Supreme Court also, lordships. And because of that, lordships, I pray for listing the matter in the next week, lordships. Some documents also I have, lordships.
Okay, we grant some time, 23 matter, but next week, see, unless Mr. Sharma, we are making very clear, this order was passed in your petition on 24/7/2023. This order is not the subject matter of any further challenge in the division bench. In that view of the matter, we are bound by this order. This order has also taken into account your submission that the area was covered by the Gao Panchayat and you had no notice. And Land Standing Council was directed to produce the relevant notification, which was it done, Mr.?
Yes.
It was done. Okay, we adjourned the hearing to a date, but whatever has to be done, you do. Otherwise, we are going ahead with the hearing. Sri R. Sharma, Learned Counsel for the petitioner, has prayed for an adjournment by submitting that there are certain developments which you would like to place on record. Para. Sri P. Nayak, Learned Standing Council, GMD, has however submitted that this court, while entertaining this petition on 24/7/2023, had issued certain directions as per which the petitioner was himself given the option to remove the illegal setbacks, and with a further condition that if the same is not done, the authority would have the liberty to go ahead for such removal. Para? Yes. The aforesaid order has not been put to further challenge by the petitioner. Full stop. Para. Be that as it may. List this case. This case is adjourned to be listed on. We'll have it on when? Today is
16.
We'll have it on 6th of November. Enough time. 6th November.
All right, sir.
Yes, sir.
This is the matter, my lordship has heard on 14, an order has been passed.
Yes.
Now the liability is upon the national highway. They have used our private land as dumping yard. So that is the issue, my lord. And we, as per last order, my lord, some of the petitioner name has been removed, only petitioner number are claiming here, madam.
Yes.
May I please your lordship? This is the fact, because NHA has required the land for construction of 4 lane. That land was acquired through competent authority, that is Secretary Revenue Service.
Yes.
Revenue Authority. Now there is an there is an agreement between the contractor and us. Whatever land ROW means right of way, we are to pay if any damage is caused beyond right of way. That is means beyond acquired land, it is done. This contractor is liable. Accordingly, this agreement was there, my lord. Now, what happened? This furthermore, it has done road constructed. Thereafter, some persons, incumbents, filed, approached the authority concerned that our land is being utilized for dumping of the wastage and whatever maybe this got damaged. Then thereafter, what happened? We have written, this is not only 1 or 2 cases. That is why we have written the ministry, minister himself has written
Ministry of Red Transport and Distribution to the government of Assam to look into the matter. Then whatever sanction is there, amount has been there. They to look into the matter because not only these petitioners, my lord, I am truly speaking, some other persons also affected. Do not be before your lordship.
Yes.
Now, thereafter, this matter has come from 17 onwards. It is rightly, it is going to be, I think today it is finalized, my lord. At least I hope this way. Here, my lord, now, as your lordship is aware, this payment, compensation, or anything, whatever it is required to be paid to the incumbents affected person, that is by the competent authority of land acquisition. That is demands goes to us, general PCD I'm telling, that demand goes to us, requiring agency in turn will pay to competent authority in turn will pay to the affected person. Here, question is coming, who will pay? That is the question here involved now. Because as we in our affidavit, we have said that it is a contractor is liable. Now, we have given address also to him to make him plead as a party. They also made party, they are not appearing today. That is why, now again your question to your lordship has come that who will pay now? Because they required, according to your lordship, that's required by NSI, that is why. But here question is coming, my lord. Thereafter, the committee has been constituted by on the basis of color. Now they have filed affidavit. So what is the stand of that? Affidavit, by this affidavit, if we go through, my lord, that affidavit, 17/12/2024, my lord, that is starting page is 57. My lord, in that affidavit filed by, that is by, my lord, person number 4, that is the Secretary Revenue, Dimahasa Autonomous Council, who is also Kala, competent authority for land acquisition. Now, lordship may, they are basing on the documents, annexures, page 60 of my, page 60, my lord, these annexures, they have annexed on the basis of that annexure, Lot Patuari, IC Hamangi, Hanangajau, and Seal Village. That on the basis of that, it is affidavit prepared and filed before this honorable court. Here, if we go by this one, according to that, now, my lord, they have verified. Now, before that, I have to say honestly, one affidavit is filed before that. But this has come after this government has, central government has said to look into the matter.
Yes.
Thereafter, now they have verified the documents of this one. They surveyed the document, land area. Then it is petitioner number 1 is not affected.
No, those we have taken into.
No, that's not coming, my lord.
No, you come to the last order. Why did you come to the last order passed by this court? Everything we have seen.
Yes, sir, that
That's the last order.
last order.
No.
Please read.
Third, this one.
Yes, third paragraph from the pleadings. From the pleadings exchange.
Pleading exchange is with the 13 numbers of petitioners have joined recent communication data affidavit 17 by the respondent 4. That petitioners 4, 6, 7, 8, 7 are not interested in the pursuit case. Mr. Borua, the learned counsel for the petitioners, have also fairly submitted that those petitioners not tasked with him.
Ms. Decker, then.
Mr. Decker, Ms. M.S. Decker, the learned standing council has further informed that petitioner number 3 has passed away and there is no substitution in the meantime. The matter would ultimately revolve around the claims of the petition number 1, 2,
5, 9, and
11.
Yes, only this.
Considering that the first affidavit said this one, affidavit dated 18/12/2017, a report dated 31/5/2000 of the last quarter in charge has been enclosed, which in connection with certain damages suffered by the petitioner. Shri Boru, this is my colleague. The learned counsel pressed some time to recon. That is the thing.
Now, though there were 12 number of petitioners, we have seen that the present claim has to be adjudicated for petitioners number 1, 2, 5, 9, and 11. 1 and 13 has passed away. No, 3 has
Three
passed,
passed away.
3 has passed away, and 4, 6, 7, 10, and 12 are not interested. So for these 5 number of petitioners, how is to be resolved? And there is an initial report that they had
No,
indeed,
that's correct.
they
Yes,
had
my
indeed
lord. Yes,
suffered
yes.
certain damage because of dumping of soil in,
Sir,
in their area.
That was first affidavit.
First affidavit.
But subsequent affidavit has come.
Yes.
Whether it is the lordship will take into corroboration or that is lordship's pleasure.
Yes.
But that affidavit is not that some separate view is taken because not affected. But that is not countered by the petitioner. This whatever this affidavit says, if it is not affected, my lord, not affected. Here question is coming, my lord. My experience, I'm saying, my lord. This well, this all surveys. Even today, if it is going surveys carried out, some other things will come out. That's the problem. Anyhow, my lord, lordship, now I'm leaving to lordship because as we have already constructed the road, then this matter is entrusted to for payment and other things, whatever it is, to government, my lord. Now, I may be wrong, my lord. I may be allowed to only submit that matter of record. Those already they have filed affidavit. Lordship may give direction. Because it's the Kala. Kala has to do each and everything. If at all is required by NSI also, that will be paid to Kala only. And if it is state also is to be paid, then also it is to be paid to Kala. Kala in turn will do all these things. That is why let Kala verify, and if they are entitled, they are interested for money, Miller, compensation. They are interested for compensation. Now, it is only submission, don't otherwise.
Sala will look into acquisition compensation or any other compensation.
No, acquisition, all things to be by the Kala.
Not only acquisition.
Not only acquisition, because further acquisition, even when go arbitration, is to first approach to Kala. Because it is a question of acquiring land. Because we are demand only for acquiring.
No, Mr. Borwa.
My lord.
See, while constructing the road, widening of the road, you acquire certain portions.
My lord.
That is the acquisition compensation, which may also include Jirat compensation.
my lord.
Now here we are not on acquisition compensation or Jirat compensation.
Yes,
It is damage which they are claiming, and that too on the basis of a document which has been enclosed to an affidavit of opposition. Initially, they did not have any materials to make such claim.
Yes,
In the affidavit filed by the NCL's authority, they have given a report of the Lat Patwari, wherein certain damages have been verified and even amount have been stated in that report.
My lord.
If that report was not there, perhaps it would have not have been very so difficult for us.
Yes.
They did not even
Yes.
base their claim on
No.
anything. It
Yes,
came in the
yes.
affidavit of the department of the council.
Yes, that is.
Now that affidavit was also later on modified, saying that no, all of them have not suffered. Now we get only 5 of them, 1, 2, 5, 9, and 11, for which in the first affidavit there is a report specifying something. We are not saying that that report is sacrosanct. It report may be erroneous, report may be malafide, but one consideration has to be given. Whether they have suffered damage, and if at all, then they have to be compensated.
Yes.
This
No.
compensation, as I have told, is nothing to do with the acquisition of land or Jirat.
No.
It is
Yeah.
only for suffering damage because of dumping of soil.
Dumping of soil, that is lordship. That is.
And we can also add that normally we would have asked Mr. Barua to go to the civil court, prove their claim. Now, in the affidavit of the council, you give a report.
No, here question
And
is
they have
coming, my lord,
communicated.
here. Lord, not only this question up to this affidavit, it was other side. In other way, it was something like, but this affidavit, which is filed before your lordship, this is on record. This also is to be taken into consideration.
No, you
Whether it
see,
is either way or this way,
No,
that
we
is
have
something
taken,
else.
we have taken into consideration.
No,
Please
because here the
see the report of the
yeah,
Lat
latest
Patwari.
Lat Patwari also report is to be looked
Lat
into.
Patwari's report, we have
Yes.
taken into consideration. That
Yes,
is,
my lord, the opinion. Here, if you go page 60, my lord. Lordship got it, page 60, that Patwari.
yes,
report.
yes.
Dear Lordship will get it now. We want solution. Before that, I'm telling you, my lord, we want solution because we also do not want to proceed. I want personally, before going on this, my lord, I want they should get money because they are affected person. Even I am also affected from my land in my own place. But this question is coming now, who will pay?
May I clarify one point, my lord? That earlier inquiry report, my lord, it was already communicated and their copies also there in the affidavit dated 18/12/17, my lord. They themselves have communicated to us, my lord, that this is the damage caused to your land. That is the thing, my lord. We have communicated the first report, my lord. And that they cannot deny now, my lord, especially by letter, my lord.
But you have also not come with that reply. You have
Not
to take
necessary.
It is necessary.
Because
It
my
is
lord-
a necessary counter. It is not once is not filed is admitted. Here, my lord, another part is there. Lat Patwari has said here, my lord, petition number 4. That day, your lordship, it was placed before lordship. This one also, it is your lordship before lordship is there. Here it is there. That is 13/8/2024. They have submitted a report before lordship. Whether it is in record or not, it was given to me. There it is saying petition of 410 payment has been made within ROW. That was within ROW. That was within. Now,
We see there are factual disputes. We'll do one thing. Since we have clarified that it is only for 5 petitioners, this something dispute appears to have been existing. We'll direct these 5 petitioners to approach the CALA.
very
CALA will make an examination.
yes, my lord. That is
Because
my
there are 2
submission.
conflicting reports of the Lat Patwari.
They-
One says that they have suffered damage. The second says land is not affected. Let a verification be done
Yes.
and
Yes.
My lord, second report is, my lord, no contradiction. Thing is, there my second report, after 8 years, they have gone to the site when the entire dumping here has become a hard substance. It is not possible for any cultivation, anything. So second report basically should have been for assessment, but they have gone and found that it has turned into hard substance. Therefore, they are saying that that cannot be taken into account, my lord. After 8 years,
Late.
the 8 years, my lord, it cannot be, my lord. It's not a, my lord, with any bona fide reason. The first report is the genuinely they have communicated. The later your lordship will find in the affidavit dated 18/12/2017. Along with the inquiry report, they have communicated and it is annexed by the revenue department, my lord. Kindly see, my lord.
I have seen, but even if it is turned into a hard substance, then that thing can be proved.
Yes.
The dumping can be proved.
Yes.
And if for that you are not able to make any cultivation,
Yes.
the damage will be paid to you.
My lord, if for a thing, if it is used, can be used, there is no question of this one.
My lord, only thing
Definitely,
that
that
first-
is dumping will be
first-
there, my lord. If
first
dumping is there, he cannot go for that.
No.
Once he is claiming, he cannot go. Always dumping will be this one. Maybe like our madam, it may be little bit, it may be less, but it will be there like madam. Dumping, it is not a question of 1 truck or 2 trucks. Dumping word itself, it is a very substantial amount has been this one. There is a lordship that is the this one. And apart from that, my lord, if we go by legally, my lord, what prevented you to at least counter on this point? Now, this one, this should be, because it is a law point, legal point. I should be also, we should always, we should be also,
my case was
otherwise
entirely
we
on
are
the
same
case,
problem, my lord.
It is
Now,
not against
why it is
education.
not required? It is required very well. What is the provision of filing counter? Anyhow, my lord, lordship, rightly being observing, Kala will look into, and one thing also maybe, this one, if it is, it can be closed doorja, only my humble submission only, my lord, this one. If Kala founds, he will do needful. From where? He will write down to, if it required to, he write the government or he will.
In NCL district, who is the Kala?
That is
Secretary
the-
Revenue.
Secretary Revenue, my lord.
Okay, let us see what are the functions of Kala. Yes, can you assess damage? Can you assess the claim for compensation? Kala is competent. No. We not on the officers. Is Kala entitled to look into aspects which are beyond the aspect of acquisition of land? Or is it only confined to acquisition?
Yes,
I just, because if he's not competent to look on other division, then no point passing such a. Just. And he reconciled, National Highways Authority. Mr. Barwa, I think you'll be the best person.
Yes. Here-
CALA
Yes, yes.
can
Here-
determine
here-
compensation for what aspects?
That is why I like to, if for your permission, I have filed one affidavit, which notification is there.
Yes, please read.
My
Please,
lord,
please,
notification, page 87, Lordship may look into. My lord, may I read? Or Lordship is a page. Lordship got it, 87? Page?
Right. I think 3G2 will cover. 3G2,
National Highway Act.
National Highways Act.
Yes.
Because 3G1 is essentially confined to the acquisition.
Yes.
Where any land is acquired, there shall be paid an amount which shall be determined. Now, 2, where the right of user
Yes.
or any right in the nature of an easement on any land, oh, is acquired.
Yes.
Oh, no, not this. Oh, sorry.
Correct. Correct. You put it in what I'm saying.
No. We know Kala is there. But Kala is to determine only a compensation for acquisition of land. He is not
Yes.
paying for any compensation for acquisition of land. He is paying for damage for use of the land for dumping of ground, as a dumping ground. Kala under what? Which provision? This Kala comes, the jurisdiction west on the Kala under the National Highways Act of 1956.
56 T small a.
Now, if
T
you
small
go
a.
to the aspect of compensation, 56 3G. Mr. C. Barua,
My lord.
3G, 1 and 2. 1 and 2 are the only aspect where acquisition, where compensation can be assessed. Please read 3G.
I'm reading, my lord.
Where?
When a land is acquired under this act, there shall be paid an amount which shall be determined by an order of competent authority.
That means when the land is acquired.
Acquired.
It is only
Now,
for acquired. Next,
Where
number 2.
the, next point,
When
where
the-
the right of user or any right in the nature of
Easement
on
any land acquired.
acquired under this act, there shall be paid an amount to the owner and any other person whose right of enjoyment in that land has been affected in any manner whatsoever by reason such acquisition, and amount calculated in 10% of the amount determined this and so and so. Before proceeding the
No, it's 1 and 2 only.
here another point.
Both are
Now,
confined to
Kala, your lordship, due permission, 3A, small a, we have to.
No, we are not on whose Kala. We know who is Kala. But we were on the aspect what Kala can give, determine and give. Kala can give compensation only for land acquisition.
Yes. Here, may I take one notification only for answer justice? This page lordship 87
Of?
That our petition.
Okay.
It's a affidavit.
Okay.
That is 87.
Yes.
So it will may help us sometimes. Notification dated 21/11/2023.
Yes.
Lordship got it. Issued by-
21/12 or 87.
It is public NH department is for notification. Lordship. Here.
87. Can you give us the date of the notification?
Lordship will get it. if we read it, where National Highway Authority has undertaken the construction of.
Is it 21/12/2023?
Yes, my lord.
Yes, yes, we've got it.
Yes, my lord. Whereas the National Highway of India had redesigned the structure so and so, wherein distribution commenced by the disruption of works. Where is third paragraph? 1, 2, 3, 4. 4, 5. Lordship.
Yes.
Whereas the competent authority in NH has made it clear that demand for compensation beyond right of way, that is ROW, for the project is not payable by the authority under the provision of NHSEC relevant guideline of the NHI authority. Whereas the revenue secretary competent
Okay. This will cover perhaps. You're correct.
formula. That
This is beyond the right of way.
yes, my lord. That
So
is-
for this committee is there,
Yes,
damage
yes,
assessment
yes.
committee. Yes.
that is there.
Yes, you go before this damage assessment committee. Principal Secretary.
Very beginning onwards, I was submitting, my
But
lord.
this
Let
damage-
them go to damage committee. Even honorable court also passed an order directing him. Even my request was there. At least you go to damage committee, file application. Let us see what will come.
Damage assessment committee has come into effect from 23, my lord. And
So-
it is in respect of another highway, my lord, lane. Where the student organizations were, my lord, protesting in respect. That is the thing, my lord, and I think that exercise is over. The next
No.
phase is says only for 3 months.
My lord,
Next
one thing,
phase says
I
that
can
is
say
for
one
3
thing,
months.
my lord, your lordship has
Committee
announced.
That
Under
is
that-
over only.
Completely
lord.
enter within 3 months.
Yes, my lord. that
My
is
lord,
over.
3 months, no doubt.
How can
That
we
was,
assess-
no, it was your duty to go to damaging committee. You have
This
not
was-
gone.
this
Now
was
they will
never-
constitute. What is there?
Never stated, my lord, that this is the committee.
Committee, whether,
constituted.
why they are hesitating to go to committee, we are not understanding. Very beginning onwards, this is a case I am conducting from 17 onwards. The day it has come out 23 onwards,
in
my
that
lord,
case, my
I
lord-
have requested him personally even in court.
In that case, my lord,
That-
highway has to pay the compensation, our submission. my lord. We'll
No,
claim.
in that case, Kilika, if we stick up this one, then what? Because we have constituted a committee, we are not against the only this one. Then I was insisting all along, my lord, from date of 20, that 21/12 onwards, that at least you go and approach the committee. Even you go and approach the committee, file the application. What result will come? We'll look
My
into
lord,
it.
But
lordship
the
will see.
committee which Mr. Barua has pointed out,
Yes.
it
The
was,
3 months.
it is for 3 months.
3 months, now lordship, the matter is before lordship.
No, before, but this committee is not functional.
No, this committee can be reconstituted. What is problem for him? If the matter is pending before his honorable court, at least let them verify. What is their, they want money, but they do not want to go.
This is a my lord, different process. They are
Now,
adopting.
they are insisting very beginning that they are, why, you want money, from where it is coming, it is not a question. You want money, you will get it.
No,
Where even central government is taking into
no,
consideration.
that process will not
This is
be
not
really
applicable.
correct. If the committee was existing, maybe it is for a different highway, but still then we have asked the petitioner, the affected petitioner to approach with a direction. Now this committee of 2023, we are in 2025 November.
No,
Yeah.
lordship made direct.
Now this
Kala, direct Kala, that you verify, what
No, no.
manner he verifies.
No, Mr. Barua, that is where we are finding a little.
That is, my
difficult.
lord.
No, we are finding a difficulty because of that, because we want to know what are the duties and function of a Kala.
Right.
Kala can determine compensation only for acquisition of land.
Yes.
As you have understood, he is not claiming damage for acquisition of land. He is claiming damage only for the dumping of soil in his land. It is beyond the right of way.
Their claim also beyond the right of way.
No.
Their claim is beyond the right of way.
Beyond.
If it is beyond the right of way, Kala may not be the appropriate authority to conduct.
Lordship pass. Now, if this committee is there, one committee has been they can reconstitute a committee for particular these people, because somebody has to assess it. Some organization, some authority to assess it. Because
No, we cannot direct constitution. We can direct a particular officer of the
Yes.
administration. That can be done. But as a Kala Hill, I think there will be difficulty. If he acts as CALA, then CALA will be confined only to 3G1 and 3G2.
Yes.
And both 3G1 and 3G2 are confined only to the process of acquiring the land. Their land have not been acquired. It is only suffered damage because of dumping of soil.
So their
No.
project director is there, my lord, National Highway.
No,
They can
no.
jointly do, my lord, project director and revenue is there, my lord.
Yes,
Lordship may
better is
direct-
same, okay, word is left with a Scala. We delete this word. For time being, we forget about
Yes,
Scala.
yes.
Whatever he's submitting, that is also can be project director and the revenue authority. Revenue to decide, we'll see. And they can, even Miller,
Your PD project director is at stationed at where?
the
And Seal.
project director, our project director, NSA,
Haflong, my
Haflong, he's now presently office in Silchar.
nearby.
Haflong is the Silchar city.
No. Is he there in Assam? Can they
Yes,
approach him?
Our project is there, Miller.
No, not only project. If the officer is stationed at Delhi, then it will be
No,
difficult for the
no. Then
petitioner.
my-
Our project, I'll tell you, project officer always in project.
Project director.
And one regional officer also there, they are not there. It is to be seen by project director and it is to, project director is available, Miller. Project director, because project is going on, Miller. Some construction is going, development is going on. Our project is there. Project director is there. Who, that may, officer may not be some other officer today.
And one representative of the council, yes, Mr.
Yeah.
Das.
Council, revenue authority. No, revenue secretary is the authority. They will look into the matter if, and they will, one more observation, Lordship, my humble submission only, maybe made. Then whoever is, if they are found, they are entitled for that, that can be ascertained by them who will pay. If they are saying, because here, yesterday, actually, off record, I am submitting, I am trying all along for allowance officers. But problem has come here, we resisting for payment from our side, because that is, this another problem may come up for us. Today it will be, but tomorrow it may come up. Why? Because already ministry has written to the government, Assam government, that beyond right of way, whatever affected person you pay. 930 crores or something already. That has been state government. And state government not refused to do so. Even from this affidavit also it is said, some people have.
Now suppose,
My
Mr.
lord.
Barua,
My lord.
the committee finds some merit in their contention
Yes.
claim, and committee comes to a conclusion that yes, X amount of rupees is liable, is the petitioners are entitled. Petitioner
Yes.
so and so are entitled.
And
Who will make the
that
payment?
is my another submission. That is another submission that they will decide. Because these offices, they will officers, NSA authority and state government will decide. Because already matter is entrusted to state government for payment of this one. They are not denying on that point. They have entrusted, even my lord, even I may be wrong, because some people have withdrawn the case. I may not be correct, because I should not say, but my doubt is there, they might have received the amount. Some people might have received the amount from regional authority concern. Because otherwise, until and unless 7 or 8% cannot withdraw the matter, they might have got it. That is why they will also look into that also. If they have got it, you will also get it. If entitled. That is the simple solution, my lord.
Now who will pay?
Right, that is why they will see, we'll decide ourselves who will pay. Somebody has to pay. Either state will pay or NSA. They will decide.
That will be leaving it very vague.
No, very not big. The order itself will be clear that they will decide among themselves, between Assam government and NSA. This will be done. That is why it will decide. Whoever is liable, he will pay. I am here. I will also write down that manner. Your entire may not be there, Lordship may not pass order.
Lordship, there is an order of this honorable court on this issue on 15/3/2021 by Justice P.K. Dekam, my lord. 15/3/2021. (15/3/2021), my lord. In there, it was that contention was taken in that. It was stated very clearly, my lord, that all the petition and the company.
Six and seven. Who is
Yes.
6 and 7?
National Highway and their contractor. That is the thing. There is a juridical relation. And from that day onwards, my lord.
Even
this-
simple word is vicarious liability. That is called vicarious liability. But here
That is the thing.
it
my
is
lord.
also one of the question, because this matter is taken into consideration. If it would have not taken into consideration by central government, then it would have been else. Because central government has clearly asked the state government to look into the matter and assessed also some amount in 900, 930 crores something amount. Already been this one assessed. That is, if state government and state government has not denied on that point. Now that is why, if we are saying, if he's saying for insisting of for NSAI, then again I have to come before Lordship. So whoever is, if they are entitled for compensation, whoever is to pay, they will be the government, because we are government. Both are government. It's not a private. Actually, if at all it is to go by law, it is to be contractor. Contractor, what action has been taken against contractor? Once he has appeared, or not appeared, he's made his party. I have given by affidavit.
Contractor of the highway
certificate.
authority. That is the.
Highway authority, no, what? This is their highway authority, the contractor that is to be seen by honorable court. Vicarious liability, how much it is applicable?
There is a lack of supervision, my lord, defective supervision of the national highway to maintain any dumping yard. And therefore, my lord, highway is liable for using the paddy land, my lord, private land, of making it unfit for cultivation and for survival, my lord. And the first report is very much clear, my lord, that.
Your PD is PD, National Highway Authority, NHAI, what do you call? Project Director
Director.
of?
PIU, no.
Project implementation.
PIU, Project Implementation Unit. Haflong. We have 5 projects, that's why this is Haflong.
It's already there, my lord, respondent 6, I had made part in it.
And Revenue Secretary, respondent number?
Secretary Revenue Officer, respondent 4, my lord.
4. Okay, we'll pass an order to,
Yes.
that they'll approach this remaining petitioners shall approach a committee to be constituted by the project director, PIU, respondent number 6, and the Revenue Secretary.
Yes.
By filing separate petition with separate representation, they will be given an opportunity of hearing to prove their claims. And if at all they are found to be entitled to any amount has to be paid by the NHI. We will give you liberty to extract that amount from the contractor. Because this order of 15/3/2021 is there.
Lordship, only this one, Lordship keep open. Day one, a very beginning I have submitted, we will pay, but who is
Now
to
we'll give
pay?
you liberty to extract from the, make the
The
recovery from.
contractor.
See, the
because-
contractor was made
No,
a
no,
party,
find out what
he has
happened.
chosen not to come.
No,
Directing the
it will be
contractor to
difficult.
pay will be useless.
No, difficult, matlab, that is why I am not telling contractor, I am avoiding. Why? Because
Mr. Barua, if
No.
for NHI it is difficult to make a recovery from the contractor, how can the petitioner, poor
No,
villagers do?
petitioner, I'm not asking. I'm not asking. Very beginning, I'm telling that they are entitled. But only question to be kept open on only NSCI or state government. Because already it has been entrusted to state
No,
government.
this order of 15/3/2021 has attained finality.
That is the thing, my lord.
Is,
This order is there, we'll take record from that order.
thereafter, because
Lordship may take account of the first inquiry report, my lord, 31/7/17. That is, they
no, this
communicate to us, my lord. That is
no,
the thing, my lord.
if
This is
so,
part of their
if
communication.
so, and up to today documents to be taken into consideration, not only this one, proceedings, all these documents or whatever readings, up to today it is to be taken, only 17, why
The
now?
Other things have become. hot
Why
subjects now.
other affidavit is to be denied?
No, other
Lordship's
affidavit-
pleasure, whatever passed in order, Lordship's pleasure, whatever order is
No,
passed. But
Mr.
documents.
Barua, Mr. It's our pleasure, but you have to assist us to.
No,
come
I'm
to-
assisting.
Come to
That is
a
why, my lord,
come to
that
a
is
right,
why-
right direction. If-
Right direction I'm coming.
Yes.
That is why I'm telling, taking into consideration of this affidavit also. This affidavit also is affidavit also today, last affidavit.
Yes.
This may be contradict. The Lordship has.
No,
And
Mr. Barua, that is only on the aspect of entitlement. If the committee finds that they are not entitled, matter ends there. So if the committee finds that they are entitled, who will pay the money? Now we have an order of 15/3/2021 saying that it is the NHA and contractor who would be liable to
15
pay.
of my lordship.
15/3/2021, Justice.
21.
Yes.
That is why, my lord, lordship, now another submission is there. After this, I have communicated. Matlab,
Yes.
I have already informed them. That is why 23 has come. That government,
Yes.
ministry has written to letter to state,
Yes.
only considering all these things. That is why state government was asked to pay the compensation 930 crores. That is after decision. That is what taking.
Where is that 23 letter?
So.
Where is that?
No, but it's condemned. I mean, petition is there. Yes, sir. We have you 930 crores, sir. Is it city Gandia? No, city Gandia. Yeah. 32.
Is it a part of the records?
Not record. No. Record be record. Only just glance measure. This is also documents. That is also official documents. For ends of justice, they want supposed to get money, they should get it. Eh? Oh, acha. कितना बिल है? कितनी बिल है? कितनी बिल है? Condition dia sana. Or
No, there is this, it is only 32.31 crores was the
yes.
estimate. What has happened thereafter?
Thereafter, what happened, my lord? This one, they have given these documents to us. Here, I'll read it, my lord. Otherwise, it will be marking. We have put marking. Here, 4 and 10, payment has been made within ROW. That was ROW, it was paid. Now, 6, 7, 8, 12, petitioner, bill estimator has been sent to Govt of Assam for payment beyond ROW. It is the same issue. See, lordship, again.
What are you reading?
No, I'm reading this notice. No, that's something.
No, what is that?
No, I'll submitting, my lord.
No, is it a part of
Part
the
of,
report?
this is not a part of, because they have given us.
Not part of it.
Achha, my lordship only, this one.
No, if that is taken care of, Mr. Barua, it is taken care of.
My lord, only I am reading this one. What? Because what manner it is going, he also doesn't know. I also.
No,
because nobody
Mr.
can-
Barua, if you have written to the state government.
No, 6, 7.
No, just listen to this quote. If you have written to the state government for the damage to few of the petitioners,
No, that
we
is-
direct the state government to explain
Yes,
this matter.
yes, Lord Patwari has written this one, 6, 7, 8, 12, it is sent for payment to government for ROW. And these people are, my lord, these 6, 7, 8, and 10 are withdrawing. That is why my very beginning I submitted their possibility, because other unless you're fighting from 17, because 6, 7, 8, 12, it was sent for to government, and these 4 people are withdrawing the petition.
This was never taken into account.
He
Committee was.
if
not
you
in
say
existence.
this way, then I can bring not on record. He also
No,
not.
Mr. Barua, we have already taken this into account.
Yes, my lord.
In the affidavit filed on 17/12/2024. Kindly, you have to read the order of 14/10/2025. Can you read the order of 2014? This is not required. 14/10/2025. Can you read?
14/10.
We are not even adjudicating for 4, 6, 10, 6, 8, 10, and 12.
No.
Can you read the third paragraph
Yes.
from the pleadings exchanged?
Kuntu asile?
From the pleadings
Acha.
exchanged.
This one. Yes.
We have already, we have,
No.
those are outside the purview of
Yes,
the
yes,
adjudication
there.
process.
No, here your submission only this way. This I have seen, and your lordship is rightly observed because they are withdrawing division. Then it is to be seen these people's name were sent to government for payment. These who are withdrawing the petition before 4, 6 and so and so, and their names were forwarded to government for payment. They might have received the payment. My here submission is this way. If these people have got it, these 457 as withdrawn, nobody will withdraw otherwise until unless some benefits come out. And it has been withdrawn, and their names are forwarded for payment. If they are getting it, they will also get it. They might have approached this one. That is my submission before, honestly speaking, my lord.
Well, that is not correct, my lord, because the revenue authority is the base authority, my lord.
Now he is asking me to pay. Now whenever I am submitting, now he is telling revenue is the base authority.
The revenue.
And now he is insisting payment from me. Both the way you don't play game.
It was sent to the government, means the government of the council or the state government?
It is the government of Assam, my lord. My lord, my friend will be better way because he has brought instruction. I know. That who brought.
Who has? Yes, Mr. Das, anything?
Lordship considers this one because last night which instructions I have received, that is the letter of correspondence between my learned senior and his official. As per that agreement, subclause 301.3.11, that the portion which is beyond right of way has to be paid by the contractor. That is clearly stated in their agreement, Lordship. This is the letter which my learned senior had written to the authority, Lordship, which I have received.
No, we are not party to the agreement. That is the thing.
No, agreement, these petitioners cannot be a party. That is the party between the contractor and the
that is between them.
National Highway Authority.
That is their.
NHAI.
This is already in
Yes.
stated in the affidavit of opposition.
Yes, Lordship. That is what, Lordship.
Now, how do you resolve the issue now?
What
Contractor is made a party, he is not appearing. We do not even know whether the petitioners will be actually entitled to the compensation. If there is a factual determination which ends up in a conclusion that they are indeed entitled, then who will pay the amount? Two issues, both are in a very liquid stage. There is no certainty on this. There is an agreement between the contractor and the NHAI. Contractor is not appeared. Even if we direct the contractor to pay, they will not get anything. But first, this direction will come only if their entitlement is fortified, is recognized by law. That also is not there.
Yes, Lordship.
And my lord.
Then my submission will be, Lordship may direct a committee to be formed under the head, Principal Secretary NC Hills may be directed to form a committee along with the officials of the NHAI and the revenue authorities. Let them assess, and if they found eligible,
then who will pay?
Then it will be paid by the NHAI.
National Highway.
National Highway. If they are not able to track the contractor.
This time I am not denying also, but only it is to be looked into because state government there.
Because as per the agreement between the NHAI and the contractor.
My lord, it is to be decided by, because already they have sent for government, and those who have sent, names are sent for government payment, they have doing the case. Meaning thereby, this payment is made by government. And we have also written letter to state government. That is only, right, that is. Maybe
Because in this case,
Okay, civil code. B. Barwa. For the petitioner. C. Barwa NHAI. And Sri R.M. Das, Standing Council. And CHAC. Hearings concluded, judgment reserved.
And my lord, the first report assessment that may be taken into account by. Because that is the main, my lord, under which they have submitted the report to us, communication letter is there. That is the most authentic document, my lord.
Will passing order to all districts here. This is nothing to
Obliged, sir.
dictate or.